Self-defense rests, let's lay it down. Gonna dig deep, wave that verdict round. The defense rests, time to analyze. With the evidence, we'll unveil the crime. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Good morning, my lovelies. How art thou? Oh, I sound very loud in my ears. Am I very loud? Good morning. Welcome to the defence rest. And the defence didn't get much rest, but that's okay. We live to tell another day. And today, it's the day after Thanksgiving. Did we all have a lovely holiday? Did we all eat far too much and lay on the couch and unbutton our pants? Good morning, sweetheart. Good morning. Morning, Christine. Good morning, Anna. I'm not too bad, Madal. I'm not too bad. I could do with some more sleep. It's I'm still not used to getting into the shower at 11 o'clock at night and getting dolled up and getting dressed. It's like I'm all dressed up with no one to blow. Yep. So you're welcome. Oh, I'm glad you all did. That's great. Excellent. So your turkeys didn't burn and they were stuffed to perfection. I'm assuming. I hope you all had a fantastic Thanksgiving, and I'm pretty damn sure that Mr. Ty Tucker probably really enjoyed his as well. Oh, thank you, Anna. It's the beauties of makeup and StreamYard filters. They do wonders. Oh, caffeine is good. Right, so we begin a new one today. There is a bit of an update on Ty before I start. He did get in contact with Steve yesterday, and he was released after the hearing on the 26th in the middle of the night with nothing. So he was supposed to get his property back, but by the time they processed him out of the jail, the property office was closed. So he had no wallet, no ID, nada, nothing. So he walked the streets for the night until he could get back in the next morning and access his wallet to I think Lauren actually bought him a hotel room for the night. So yeah. Thanks, Monroe County, arseholes. But he sounds in amazing spirits. I have got a copy of the audio for the phone call if you want to hear it later. And I have got a short that I'm going to put up while we're watching this trial. But yeah, he is happy, he's free, and yeah, he's he's itching to tell his tale, I think. Itching. He was still in Key West, or he will still be in Key West until Monday, when the property office will be able to give him back his laptop and phone. So he's got no internet yet. He's just using the hotel phone. So yeah. All right. Well, on to today. Today we are doing the Zachariah Anderson case. Now, this is a case out of Wisconsin. I don't know a great deal about it, but I know it's a fairly controversial case in that it's very divided as to, it's almost like Karen Reid. You're either with the guilty or with the not guilty. Basically, there is no in between. It's black or white for some people. Now, there has not been, where is it? So there was apparently no DNA evidence, no weapon, no body was ever found. And apparently there's no CCTV footage either. So that's all I know about the case. I believe that he's been charged with unaliving his ex-girlfriend's partner. And that's terrible. I haven't even had a chance to check his name. That's awful, Jody. That's terrible. Holy crap. That's how busy I've been. Right. Okay. Well, best we find it out, shall we? Let's do it together. So your reaction will be the same as mine because I have not seen this case. And it's not that old. I actually don't even know when it was. I think it was probably earlier this year. And it's the topic of it's the case that we've chosen to cover in the podcast next weekend on the 7th of December with Nicholas Starrow and hopefully Zachariah Anderson's brother, Solomon. They'll be joining us on the podcast to analyse and break down this case. So that's why we're covering it this week, because I need to catch up. So I may as well watch it with you. Now, where's my other wenches? Where's Miss Teresia and Miss Elizabeth and Mr. Udhef and Mr. Brybear? Where art thou? Oh, look, that hair's pretty. Udhef will pop up any second now. And I bet you Teresia and Elizabeth have eaten far too much and are still in a food coma. Alrighty, now I've got this ready to go. I don't know where it's queued. We'll just have a look, shall we? And no sound. Unmute, that'd help, Jody. Still no sound. Why is it so? Check that one, that's right. Mute that one. Maybe I'll just refresh this page.
Him in his phone.
He's got a very loud voice, doesn't he? All right, let's get back to high definition, because that's what I pay the good money for. Full screen it. So it doesn't seem like there is. Come on. Got no sound again.
Regarding the public records of anyone involved in this case.
Wasn't me, it was
Any
them.
information that you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on the jury.
We don't need jury
Do not use a computer person to suffer purpose. Acts that you may find constitute a course of conduct.
Not my type.
Are limited to
not my type, Anna.
Number one, maintaining a visual or physical proximity to the other.
Unfortunately, the rough and rugged.
2, approaching or confronting the other. 3, appearing at the other's workplace or contacting the other's employer or
the victim.
4th, appearing at the other's home or contacting the other's neighbors. other to suffer serious emotional distress
Oh, he
or
looks like one of
induce
those
fear
dolls.
in life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require
Oh, come on.
and common
With
sense.
the opening
This
statements.
is a doubt for which a reason can be given. The district attorney will lead off. And after he's completed his remarks, then the defense has the opportunity to make opening statement now, or if it is preferred
This man's voice
by
is
the
very, very
defense, they can
loud.
reserve
So I've put in
opening
some bass
statement until a later
to try and
point in the
counteract it.
trial. Again, they're not intended to be argument. That'll come at the end, the closing arguments.
Yes, if you know
And
the
then the
victim's
lawyers
name,
will be
Christine,
trying
you
to
can
convince you.
type
Of
it
course,
in
they're always
chat.
trying to convince you, but
I'm sure
they're
they'll
going
tell
to
us in
be,
opening statements.
exhorting you to
Otherwise-
come to a specific verdict. But these should
Come on.
be generally expected to be brief
Bum, bum.
and informative of what they hope the evidence will show. And with that, Mr. Gravely, if you're prepared, you may.
Gravely.
Councils, ladies and gentlemen, Judge, ladies and gentlemen of the panel, thank you, first of all, for all your service. Can everybody hear me very well?
Yes, I can
This
hear
will be
you.
several days. There'll be a lot of difficult and some emotional testimony, and I just wanted to thank you in advance for the time and effort and attention you're going to put in this case. This case has a lot of moving parts, and so though the judge has asked that it be brief in his discussion with you, I fear that I need to cover a number of things with you, so I'm going to take the time that I believe that the evidence demands to try to give you a roadmap as to what
It looks familiar.
I believe you will hear in terms of evidence in this case. I start with what I understand Sadie Beecham will share with you. Sadie Beecham, I think, will tell you that on May 17th, 2020, she felt her life was finally about to change. She had with the defendant last in 2012. So this was 8 years later since she had last lived with him on a regular basis. They had 3 children together. She will tell you that he basically came and went as he pleased. He had a different household. He did not pay
What are you
any
doing?
kind of regular
Oh,
basis.
God.
Sometimes he showed up on weekends, and yet he
He was
expected
the
and
commissioner,
anticipated that they were in a relationship,
you know?
and that simply was going to be enough. In December of 2018, she didn't want to live that way anymore. And so for a variety of reasons, they broke up. And so that relationship, that separate houses, you come when you want, when you mess up, you just beg me for forgiveness or do a gesture that tries to get the same situation where you're always in control, was going to be over. And so for a few weeks, they didn't have any contact. And then slowly but surely, the defendant wanted to have visits with his kids, which of course was fine with her. And he was able to get back in touch with her on a regular basis, trying to get back together with her, again, trying the cycle of trying to get forgiveness and everything will change. But this time she wasn't going there. It doesn't mean she wasn't nice to him. Doesn't mean there weren't times where she tried out of kindness to explain why this relationship was not happening. Doesn't mean she, didn't have feelings for him in some way, shape, or form based on their history. But she was ready to move on. And by February 17th of 2020, she was on a dating site and she met somebody where she thought maybe this will go somewhere. The person she was in contact with was Rosario Gutierrez. Now, he was from Kenosha, so there was that was a drive to sort of see what she was going to be able to make of this. But he seemed to love his kids and to have a relationship with his kids, and she liked that it might go somewhere. Now, this is the early weeks of this maybe relationship, right? It's not exclusive. And so she doesn't feel like she wants to share that yet with her 11-year-old who turns 12. And she certainly doesn't want to share it with the defendant, who is her ex. She knows him, and right in the sense that what I'm going to talk about next in the evidence, I'm going to ask you to look for a certain pattern. I'm going to ask you to consider whether the defendant, as I outline the next grouping of incidents, is an individual who shows by each of these incidents that he is overwhelmed with jealousy. You'll hear a number of communications where that is clear even from his own mouth, and that he has an overwhelming need in that jealousy to be in absolute control when it comes to Satan. Each of these incidences can be characterized as a gesture where he demands control, and as he loses control, we'll talk about what the evidence shows comes next. More and more irrational each time, more and more disturbing. And then I'm going to ask you to take a look at whether the defendant in each of these incidences shows you his determination to have absolute control by using every tool available, using human spies. A person named Steve Lentz, he texts as a lookout for him.
Oh,
Age 11 and 12 will tell you I was recruited by him as essentially a spy. And that he's willing to use electronics too. Basically, every way you can spy on another individual, the defendant was employing in regards to Sadie Beecham. So let's talk about each of those incidences briefly. April 24th, and this is just a 1-month period where the defendant slowly but surely learns no matter not get control.
I am going to try and quickly find another feed because that is shit. It's going to annoy the crap out of me. It's going to keep stopping and starting like that. Opening statements. Fox 6. That might be a better one, I believe. Get past the judge again.
Sprayed blood. Law enforcement gets there. If she has a car in her driveway, and where I know said inside Rosario's apartment. Day. On May 13th, Sadie goes down to Rosario's. She is going down for food and to watch some movies. On the phone of the defendant, when taken into custody, on that phone, we have in the phone recordings of directions that look like GPS type directions, which direct you. They are deleted, but they are recovered. We don't have every one of them, but the pattern of them gets you to Rosalio's address. This is the defendant's phone that is traveling per those directions that were deleted to Rosalio's home on the same date Sadie has gone down there. Now, Sadie is in Rosalio's home. And I want you to picture this, that this is what the evidence will be. Sadie is having one of those conversations you have as you start your meal and you're sitting down to watch something on TV. Rosalio says something specific to her about, do you want to watch this or something else? Conversations that many of you have had hundreds of times in your life as you begin to start your meal. Suddenly, right after it comes from the lips of Rosario Gutierrez, she receives a text on her phone. The text is from the defendant. And the text is an exact quote of what Rosalio just said to her. It's an exact quote that he's just texted her. Now, he tells her later, oh, that's an accident. I didn't mean to text you. That was just an accident. But his phone at that moment in time is going off a Kenosha tower, not a tower by his home in Mequon, a Kenosha tower, and it's the tower closest to where Rosario Gutierrez lives. So not only do the directions get him there, and by the way, have him arriving at the right time, but his phone places him at that location, quoting what is being said inside Rosalio's apartment. I must be in control. Every gesture has the same pattern. I must be in control. By the next day, May 14th, we are now literally 3 days from Rosario Gutierrez being dead to everyone who knows him. May 14th, the defendant now is looking for a confrontation based on his text messages to Sadie. May 14th, 4:13 p.m. You want me to stop by to meet Junior tonight? 4:41 p.m., a half hour later. Still not off this topic. So you're saying I can stop by and meet someone later. Now, none of Sadie's communications are inviting him over. Let's make peace. Let's talk. Why don't you come on over? Why don't you two meet? This is the defendant attempting to provoke, but revealing his intentions. This is a communication suggesting I am looking for a confrontation. Here's what Olivia says about the period we've talked about so far. She says, every time I and the twins come over, this is the daughter, I apologize, this is the daughter, age 12. Every time we come over, he leaves and goes to follow mom. Every time we kids come over. She says to law enforcement, I am his spy about mom. I did it to please him. Here's a plan that she describes, age 12, to law enforcement that the defendant has cooked up and convinced her to be ready to implement. A spy operation. You ready? The 12-year-old says, on an occasion where I and the kids are brought to my dad's house because it's a visit, and where I know that my mom is going over to Rosalio's home, the plan is I will call my dad and that my dad will drive us kids back to mom's house, which of course would be unoccupied, right? Because Sadie would have gone to Rosalio's home. So my dad will drive us back to the unoccupied house. It's important I keep a key so that I can get in even though mom's not there. I and the twins will go into the house, and then I will call my dad and tell my dad, even though he's just dropped me off, hey, mom abandoned us and left us alone. This is the 12-year-old telling law enforcement that this is the plan that the defendant devised for her, his spy. And she said, at that point, my dad would report this. He would report that my mom had left us abandoned. That is the lengths that we're willing to go to get control, to end this relationship. They call it the plan. It's discussed multiple times.
Mm.
Now, on May 16th, 2020, one day before Rosario Gutierrez is never again seen by those who love him, May 16th. Remember, I told you on May 17th how full of hope Sadie was. Well, here's why. On the 16th of May, Sadie gets a communication from Rosario saying to her, would you like to come meet my kids? Rosario has a boy, 11, and a girl, 8. They're at his house for the weekend on the 15th and 16th, and she's being invited for the first time to meet his kids. And they go for ice cream. And I think Sadie will tell you that this is a truly meaningful moment in her life, still today when she thinks about it. Those few hours she spent with those kids and Rosario. She left for the night. She didn't spend the night. It was the last time she ever saw Rosario Gutierrez. But it meant something to her because it's not an exclusive relationship, but it felt like her hopes that this relationship was going to build and get bigger and get better and maybe be the relationship for her. It felt like this really mattered. Here's how the defendant was handling that same bit. Her to lay down with some Down syndrome Mexican version of your father. That's a text from the defendant to Sadie trying to impose himself in this real moment.
Did you have a full yesterday?
He's texting spy Stephen Lenz, who lives just close enough to Sadie that he can see if cars are in her driveway. So he's a good lookout, right? He's a good lookout post. This is the defendant to Stephen Lenz on May 16th, asking if she has a car in her driveway. Remember, she doesn't have the kids. So whether a car's in her driveway or not is frankly none of his business.
Excellent.
But his spy is being employed.
I hope you had to unbutton your jeans and lay on the couch.
So on the 17th of May, that's the day after this big moment where Sadie met his kids. And Sadie has said throughout this case that it feels like the defendant is some way monitoring all her communications. Everything that she's communicating with Rosario feels like the defendant seems to somehow know it in real time. And no one knows how that happened. That's how it is. So at 1:52 p.m., this is literally 8 hours before Rosario Gutierrez is gone and dead to
Have
everyone.
a good day.
1:52 p.m. Sadie texts Rosario. Sadie says to him in the text, "I want to be yours and get more serious with our
And
relationship."
no doubt he will point them out.
Okay, that's how she felt after she met his kids. That's her putting herself out there,
There's one.
right? Not an exclusive
Blondie?
relationship, but here it is. So there's some text back and forth. The defendant, Rosario calls her at 8:30 p.m. that night. This is an hour and a half before he's never seen again. And she misses that call. His last text to her is at 8:36 p.m., his phone to her phone. She never hears from him again. She tries him on the 18th of May. This is a relationship where they are in communication in some way, shape, or form several times a day during this period of time. On the 18th, absolutely no communication from him. On the 19th in the morning, still absolutely no communication from him. And so finally, she jumps in her car and she drives she drives from the Milwaukee area on that morning. What is going on? Trying to figure out what's happening. And she gets to his home in Kenosha. And she finds that the sliding door is open. You'll see in the pictures, Rosario Gutierrez has that apartment in an apartment complex that's the bottom floor, and his slider and his screen face right onto the road. So the sliding door is open, the screen is closed, and she looks in, and boy, does she see a lot of blood. She calls 911. And at the moment she calls 911 and law enforcement gets there, there will be a number of things that law enforcement focus on in their investigation. And I'd ask you to think about these areas of focus as you think about the evidence as it comes in this case. One area of focus is, when was Rosario Gutierrez last alive to those people who know him? The second area of investigation is, who has the motive and who has any pattern of conduct where they would be a person we should look to as a person who might have finished that pattern, completed that pattern, or acted on their motive and ended Rosario Gutierrez's life. And then the third, of course, area of investigation was, where is the body of Rosario Gutierrez? And I'm not going to belabor that in this opening.
I think she was talking to me, Anna. She was telling me who the victims are, not not you. I'm not sure if she is in Hef. I don't think so. No, I don't think so. I don't even know if my my Discord link's working, but I will give it a go and put it in chat. I actually had some Tanya's son was going to help me set it all up properly. Where am I? And I don't think he's had a chance to do it as yet. But I will put the link in chat for you, and you're welcome to join. Where is it? Hang on. Get the proper link with the URL on it. There it is. Ooh. Copy. Come on. Copy. That's it. And paste. Hopefully that works. Let me know if it does or doesn't. All right, let's get back.
You'll hear about very substantial efforts in many jurisdictions involving many agencies to look for the body of Rosario Gutierrez, which is never found.
It takes me down a rabbit hole.
On May 19th, okay, so this is 2 days after Rosario has last been heard from, at 11:07.
And I don't understand bots either. I wanted to put a chat bot in so that, if someone gave a super chat, it would automatically pick it up and do a response or that type of thing, or a membership, an automatic response to it. But I can't even work that out.
7 a.m., the Kenosha Police Department is at Rosalio's address. And they find through their investigation before too long that the last person in touch with him appears to be a woman whose last name is Macias, who received a text from him at 9:27 p.m. on the 17th, okay? And then she texted him back because she arrived at a building she thought was his, Turns out she was at the wrong building, but she thought she was in his building, and she calls him and texts him multiple times over the next half hour. Where are you? She'd never been here before. Are you coming out? You know, that kind of stuff. And there's never again an answer. So sometime after 9:27 p.m., the state's going to suggest to you all that blood results, and Rosario Gutierrez is no more to those who know him. They go through family and friends, and no one has heard from him since that 9:27 p.m. time on May 17th through any other method of communication. And so law enforcement focuses on Sadie Beecham. Remember, she called 911. She's still at the scene. She is distraught. She's shaking. She's overcome. And she's really focused. Members of the jury, you'll hear the officer testify. She's really focused on getting her kids safe. She's afraid that the defendant has done this and that her kids might not be safe because of what she sees. And so she is allowed to prioritize that, and then this investigation, of course, continues. Rosalio's vehicles are still at the residence. His keys are there. There is a large amount of blood all over his residence in several rooms. The outer hallway, including outer hallway in a way suggests that that door opening into the hallway was open at a time when significant bleeding happened, including sprayed blood that looks like impact type of blood. There's blood then right inside the door, as if someone is now in the apartment and they are continuing to have some sort of intervention or attack happen where their blood is spraying. That blood is all over that now closed door on that interior.
They show the crime.
It is all over the rug area there and on the walls and on the tables. It extends to the dining room table. It extends to the chairs on the dining room table. Some of it hits the laptop. Some of it is in the kitchen counter. Some of it is pooled blood throughout that area where you are first in the entrance. There is a small stick of processed wood, like a baseball bat or some other hard object. It's not a log. It's not a piece of cut timber. That piece of wood ends up having blood on it, which is found to be the blood of Rosario Gutierrez, and hair on it as well, which is also found to be Rosario Gutierrez. There is significant blood on the curtains, which are on the entire other end of the apartment from where that entrance to the hallway comes.
Bloody hell.
There is blood on the fan. There's blood on the ceiling in multiple rooms of this apartment. There is pooled and seeped blood into the carpet in the living room on the floor area, and seeped blood, a significant quantity of seeped blood on the couch that is the primary couch.
You never get that stain out.
And in the middle of the area by the couch, there is a missing area where there's blood surrounding it, but then there's a rectangled off area that has no blood whatsoever. It's pristine. Which certainly
Have you ever watched those? There is actually a YouTube channel, I think. I'm pretty sure it's on YouTube. And it's about a company that cleans up crime scenes and stuff after this type of attack, ready for the next tenant to come in. And it's more. But I just can't stop watching it.
Certainly suggests to anybody who looks at it that an area rug, a medium sort of size area rug, was there when significant bleeding happened and is now missing from that apartment. There are little splinters of wood on the couch that are also there, interspersed in the blood and interspersed in hair that is located, strands of hair located on that couch as well. Law enforcement tests several locations at various places. You'll hear where they tested. Each time they tested and they found that it was blood, each of those times the blood came from one individual, and that was Rosario.
Put salt on it?
You will hear that the blood is sprayed, meaning there was impact in multiple locations and multiple different times based on where the blood is located and how the blood presents or looks when law enforcement is present. Remember, present 2 days, about a day and a half after the event. Again, that area rug is completely missing. You'll hear that you might hear some testimony about something called arterial spray, where there's a finer, misty place there too. So some of what you might hear is blunt force trauma, hard objects hitting a bleeding surface.
Mm-hmm.
Some areas that you might hear about are more likely, or at least are possible areas where maybe a knife or some sharp object penetrated someone as opposed to blunt force. Rosalio's own phone records say that he dropped his kids off because he had them that weekend. He dropped them off on the 17th, and then he went home, and he was home by 9:08 p.m. So just within an hour of when he's never seen again. Opened a beer, drank a beer. I think maybe opened a second beer. Was expecting this Miss Macias to arrive. His TV was on, and his phone it goes off at 10:30 p.m. around, and that's found several days later, hidden in his freezer.
Ooh.
His phone and his credit cards are behind all the items in his freezer, hidden there. In the cold, the phone goes off. The last time that phone is on in any way, shape, or form is around 10:30 p.m. on the 17th. Rosalio's keys are there.
Who hides
His
it in the
wallet
fridge?
has ended up on the couch over some areas that already had blood, so it was placed there after the bleeding occurred. As I said, his credit cards were found in the apartment. There's been no evidence that his credit cards or his bank accounts or any other identifying pieces of that type have been used ever in the 1,018 days since. The home, you'll see the pictures, is filled with pictures of his two children, 11 and 8. He didn't miss gymnastic events. He was an enthusiastic baseball coach for his 11-year-old. You will hear electronic media talk about his excitement and planning for his coaching of his 11-year-old that will be starting literally just days, certainly weeks. Baseball season is right around the corner, and watching his son play baseball was one of the true pleasures of his life. 2 days after he is gone, he has in his date book, his planner, that he is going to be at Camp Timberlea with his children. Some of you may know that local summer camp. That's a 2-day. That's an experience that's supposed to occur on May 19th, just 2 days after this. He never arrives. He never accounts for this with his kids. Obviously, he never coaches baseball. In fact, neither of his kids, who talked to him all the time, who saw him every week, who were in contact with him multiple times a week, you'll hear that his 11-year-old son spoke to him during this time period multiple times per day. And there was never another split second of communication, and has not been for 1,018 days. He has missed their birthdays. He and his mother had a very close relationship, very close. And he has missed all of her important occasions in the last 1,018 days. And the kids he was so devoted for. Never, ever before missed these occasions. Never before, ever out of touch his entire life with the people who cared about him. And not a peep from him since. So I'm back to who the police should go to first. The defendant has actively admitted to Sadie that he is jealous, that he has admitted to Sadie, and then finally to law enforcement, that he took his 11-year-old, as I mentioned, to the mom's home. He has a recording of that incident in his phone, brief recording of that in his phone. And so law enforcement certainly focuses on the person who has documented motive and jealousy documented. All of this is interesting because it happens while the defendant, according to a woman, his girlfriend, Christine Remsburg, is literally living or staying 4 or 5 nights a week at his girlfriend's home. So what I'm describing to you are things he is doing only when he has his kids over, if he is actually traveling around, or he is doing it despite the fact he continues to have this relationship with, when she's interviewed in May of 2020, she says this relationship has been going on about a year, and that he spends 4 to 5 nights a week at her house. But the motive for the defendant is to end this relationship and to do anything he must to stay in control. So the defendant has his kids on this weekend of May 16th and 17th, right? This is the fateful weekend. Sadie picks those kids up in the afternoon. So in the late afternoon, she picks those kids up. And the daughter will tell you, 12 years old, the back of my dad's van, his minivan, which he used to transport us on the afternoon of the 17th, so the same day this happens, was normal. There were no bleach stains and no problems with the carpet in the back of his minivan when she last saw it on the afternoon of the 17th. So now the question is, what is the evidence that the defendant prepared for this attack, this murder? Well, one of the things he did was on May 15th, he took out $50,000 in cash from his account. When law enforcement gets there, he still has more than $46,000 in cash. You're going to see pictures of the bank bag, literally all the money still bound together. So he's got that, and the state will suggest to you that's in case anything goes wrong. He can make that quick run to some location to be out of harm's way or out of apprehension with that much money on hand. You'll hear the daughter indicate that when she left on Sunday afternoon, just hours before Rosario Gutierrez is gone, that she saw rope and duct tape, new rope and new duct tape, down in his basement. It was down on top of essentially a wheelie, a desk chair that's down there. When law enforcement gets to this location on the 19th, there is a wheelie chair down there in the basement. The daughter is completely right about that, but no rope, no new rope, and no new duct tape. So the state would suggest to you that is ideal stuff if you think you need to move a person bleeding, dead. You need to seal up a carpet, try to prevent as much bleeding as you possibly can from the body of the person you're removing from his own apartment. During this period of time, there's an extremely heavy rain going on in Kenosha and in the Milwaukee area. Very heavy rain. And so people are not out and about, obviously, in the same way they normally would be. Another way that the defendant prepares is when we go into his multiple phones, we find that the phone he usually uses to contact people, the phone that he usually uses in situations, is not being answered, though it is just before and just after, but not being answered from 7:30 p.m. to 11:19 p.m. Left behind the phone that had smart capabilities that would be tracked, left that behind, and so was not able to answer the calls and the texts that come from multiple people, including his girlfriend, Christine Remsburg, who tries to contact him multiple times because she is expecting him in those evening hours to come over. She's talking about what they're going to have for dinner. She's talking about what movie they're going to watch. And finally, she basically, sometime before 11:19 p.m., says, okay, I'm going to bed. She's expected him. And he never shows up at her house and never gives her an explanation until after he would have time to drive from his home in Mequon to Kenosha, commit this crime, and get back to the Mequon area, grab up the phone that he hasn't been answering, and now texts her and says, oh, sorry, fell asleep. Fell asleep during the exact hours that Rosario Gutierrez is never seen again. And then has a very long conversation with her, like a 42-minute conversation with her from midnight to 12:49, maybe trying to get back in her good graces. Because she's back with him the next night. She comes to his house for one of the very first times she's ever come to his house. She comes to his house that night, the next night, and then the night after that, which is the night he's apprehended. So then I want to talk about the cover-up, because a lot of times the way you can tell that somebody's responsible for something is their cover-up, right? That's a common way of determining somebody did something really bad. So officers get to the defendant in the evening hours. And so it's been 2 full days since Rosario Gutierrez is gone to everyone who knows him. And prior to police getting there, a close couple of buddies of Rosario Gutierrez who have heard Rosario Gutierrez say, hey, I've got this new woman I'm seeing. Her name is Sadie. She's got a crazy ex-boyfriend, and maybe even that he broke in my truck one time, right? So when Rosario Gutierrez is missing, and the friend group begins to understand this, Michael Campbell is the type of friend who will drive to the person's house where that is suspected in his mind and just go and try to confront the guy. And so he and his buddy go there and they beat the police there because the police are still, doing the police thing. And they bring up, hey, our buddy Rosario is missing. Do you know anything about this? And the defendant claims he's not his brother, claims he's not Zachariah Anderson. He claims he's his brother. He calls the cops. By then, these guys have already left. They're not trying to fight anybody or anything else. They're simply trying to ask a question. This guy's clearly not going to answer their question, and they leave. So he already knows by that moment that Rosario Gutierrez, this person he's focused on, who he's been to his house, he's texted a direct quote of what he said, he's done all sorts of other stuff regarding him, he's certainly communicated to Sadie many times about him. This guy's missing. When they go on the 19th and they look inside that minivan, of the defendants. They find that the back is bleached. There's all sorts of bleach stains on the back carpeting. That the seats are out, just the front seats are in, and the back third of the carpeting in that van has literally been cut out. So you're down to where the electronics is exposed. You're down to the plastic flooring under. The carpeting from the minivan is missing, is cut out. Where on the 17th in the afternoon, his daughter said, yeah, it was in there. Nothing was cut out of there. And there was no bleach. Fresh smell of bleach. Carpet cut out in the last 48 hours. You'll hear that in the early morning hours on the 18th, so let's say defendant arrives back in Mequon. By 4:18 a.m., he's searching for area stores by him and when they first open. So he puts in Menards, he puts in Walmart, he's going through all the basic stores. Which of them opens first is essentially his line of inquiry. And he ends up getting a Walmart, opens at 8. This search happened at 4:18 a.m. Okay, this is now about 6 hours after Rosario Gutierrez is last known alive. And you will decide what to make of this. The defendant arrives there just after 8, like 8:15, 8:18.
Yes,
it's pouring rain, still pouring rain, just as it was the day before. Pouring rain parking lot, not many cars. He parks as far as you can humanly park that minivan from the entrance. And he walks that whole distance in, as opposed to parking in any of the probably hundreds of spots that are closer. He parks as far away as possible. Does he have the body still in the back of that car, wrapped in that rug? He buys, with cash, bleach, rubber gloves, garbage bags, shampoo, Q-tips, pays cash, leaves, and heads over to an area where he is doing home demo and rent. He's doing some demo at a lake house in the Belgium, Wisconsin area. A little more isolated locations, not his house, in case law enforcement was already looking for him, in case the body had been discovered. This is on the 18th morning, okay, just hours after Rosario Gutierrez has never been seen. He's at that location, according to his phone, for 3 hours. And then leaves, goes to many other locations, but near that location, so within that immediate area, is a state park, is Lake Michigan, is a number of other remote locations, and hundreds of dumpsters, right? Over the course of any area in Wisconsin, there are hundreds of dumpsters where you might put the remains of Rosario Gutierrez. He's got a burn pit at his house that he has smoldering when the cops get there 2 days later. He's been operating the burn pit in the pouring rain. In it are an underwear band from Fruit of the Loom underwear, jean buttons, steel-toed boot components. Did he burn some clothes that he might have been wearing on that day? Officers eventually get into the defendant's laptop. When they get into it, they find a file that's labeled Rosario Gutierrez Jr. So it's got his name. This is before law enforcement talks to him. I mean, I'm sorry, they don't know this. They haven't been in his computer when they speak to him. But he's typed in the name, Rosario Gutierrez Jr. In that are picture after picture screenshots of Facebook photos of Rosario Gutierrez out socializing, but also a number of pictures of him with his kids.
So this was all found on the defendant's phone.
Think about whether this is obsessive sign of dangerous
Who's watching him?
To have collected these kind of photos in this folder on your laptop. It's got business info, it's got CCAP entries, it's got an electronic map that's pinned to the actual location of Rosalio's home. And then in that same file, under that same label, he's got a picture of one of these trackers. Just a photo with a tracker, like a screenshot, right? Auto tracker, voice activated, that spy equipment he has ordered and paid for just days before.
He had a tracker on the
defendant,
car as
when
well.
law enforcement speaks to him on May 19th, knows Rosario Gutierrez is missing.
Yeah.
Knows they want to talk to him about the possible stalking of Rosario Gutierrez. That's what they tell him they're talking. He knows what he has been doing. He knows the facts that we've described happened. There's no way the defendant does not understand how important a moment this is. Here's his chance. If he's an innocent man, right, to talk
Hello,
about exactly
Malone.
what the deal.
Hello. You know, you are on my to-do list. Where is it? Where is it? Check up on Bri. I shit you not. I wondered where you were. I hope you were okay. Good morning. Good morning. Did you have a good Thanksgiving? Oh, you poor bugger. Yeah, you know, it just goes with the territory, Dylan. It is what it is. Unfortunately, sitting for so long doesn't help. But I'll be all right, you know. I've got my endone. Oh, it's good to see you, sweetheart. Yes, we do love food. I love it too much. Get some rest, darling. Get some rest. And thank you for popping in. And thank you for the super sticker. That is just, you don't have to do that. But you will get to stick on the screen for quite some time. Thank you, Bri. Oh, dear. Have you seen this case, the Zachariah Anderson trial? I've heard about it, but I have not actually watched it. So, and have you kept up to date with Ty Tucker by chance? Have you heard all of the news? Oh, my washing machine's beeping at me. It's off balance. Oh dear. All right. I think so. I think so. Yeah, there you go. Yes. Yep.
Details are that will exonerate him. Let's clear this up.
I just have to go and fix my washing machine.
Here's what the defendant does.
Beeping.
When asked what vehicle he drives, he wants to stick with that he drives the Audi vehicle. In actual fact, Christine Remsburg is driving the defendant's Audi around because her car's on the fritz. So he hasn't driven that car around recently much at all. In the Walmart video, for instance, on the 18th, he's driving the minivan. When he drives the kids back and forth on the 17th, he's driving the minivan. He decides to only share that he's driving the Audi. Why not bring up the minivan? Why not tell him right away, hey, the car I'm using is the minivan. Please go search it. Go do whatever you want. Go take a look at my minivan. Absolutely. Instead, he wants to talk about the Audi. Reluctantly indicates that the minivan is a vehicle. Oh, but anybody could drive it. That's how he decides to behave, knowing how important this moment is. He acts to these officers, tries to give these officers the impression he doesn't even know this Mexican guy's name. I think they call him Junior, something like that, he wants to say. Well, he's written Rosario Gutierrez Jr. in his computer. He's told his daughter the name of Rosario Gutierrez. There's a phone message or a phone recording that he records between him and Sadie where he finally admits, okay, I told her the name. And yet with law enforcement on the 19th, he chooses to act as if this is not even a name he knows. He says Olivia gets that from a grandma, when in fact, he admits to Sadie that's not the case. He denies ever being at Rosalio's home to the officers, where we know based on the electronic evidence, both his text and his own phone, that he's there on May 13th. We know that. But he chooses to deny that he has been there. In fact, says, I don't think I've been to Kenosha. Though his phone is going off a Kenosha tower when he is directly quoting Rosalio. Then he's asked a very simple question. Again, this is the 19th. Where were you in the evening 2 days earlier? Okay? Not where were you 5 Wednesdays ago. Where were you in the evening 2 days ago? He says, yeah, I was with my girlfriend, Christine Remsburg, spent the night over there. That's where I was. Later goes off that. Later changes that up a little bit. But that's what he wants to go with. When Christine Remsburg, who has been with him the last 2 nights after he didn't show up at her house on the date of this homicide, when she's asked that question, also during this exact same time period, where was he? She also chooses to provide false information about his whereabouts. She says, yeah, he was with me, and that's completely false. She eventually is exposed because her sister says, that's not what happened. And when confronted with that, she says, okay, you're right. He wasn't at my house. So the two of them have exactly the same false information about where he was. So you are going to finally hear 2 other important pieces of evidence from the state's perspective. One is when the crime lab examines the van in question. These are people who are the experts in the state at trying to figure out whether there's worthwhile evidence and then trying to do the appropriate testing of evidence having to do with DNA in the state. And so the experts come and the van is eventually brought to them, and they go through that van and they identify a particular location that is near the back. So in that same 1/3 of the minivan where the carpet has now been cut out, but it's about halfway up and it's on the plastic panel and it's just a little speck. And when the 2 DNA and crime scene analysts, when the DNA and crime scene analysts see that, they both say, we think that's blood. But it's so small that they decide that is just going to be our observation. We're not going to use a chemical on it. We're afraid we might not get DNA if we do that. So they observe, they believe it's blood. It is taken to the crime lab. It is tested. And based on the results, again, the analyst, Lisa Treffinger, will tell you she believes it's blood. She believes that based on the process of elimination. It's not semen. It's not skin cells. It's not saliva. It's not a piece of hair. And therefore, based on the content, based on what we can get on the results, it is blood. I believe it to be blood. She'll offer that opinion to you. She'll also tell you that her test tells her
which one's got more protein.
That blood is the DNA of Rosario Gutierrez. Rosario Gutierrez, there's not going to be any evidence he's ever been in this van. Certainly that he's ever bled in this van. That he has anything to do with this van. His blood, his DNA is located on that speck.
Really?
Amidst the area, not in the same area, but in the van filled with bleach and with the cutout carpet. Cutout carpet is never found, by the way. Clothes that the defendant was wearing on the 17th are never found, by the way. Then finally, you're going to hear evidence of an individual, an inmate named Marquand Washington. Marquand Washington has very serious federal charges that are going on right now, and he's being housed in the Kenosha jail on those federal charges. You'll hear him say that several months ago, he came forward to his attorney and told his attorney that I previously roomed with, I shared a cell, I was a bunkmate with the defendant. That when that occurred, that we bonded over some common sort of criminal activity. So, we talked, and I'm not going to talk about the details, but that they bonded over some discussions of their life prior to this date. You'll hear that Marquand Washington was able to tell details about the case, such as when the police raided the defendant's residence, they found a lot of money and a little bit of weed. And that you'll hear Marquand Washington say the defendant described the house that was raided as a crappy house, but in a nice area. You'll hear Marquand Washington say the defendant told him when talking about murder that murder takes a lot of work, that you have to figure out ways to track people and stalk them, learn their habits, learn what they are up to so that you can find your moment. He suggested trackers from Amazon would be something that would be worthwhile to consider. Marquand Washington says the defendant told him that he wrapped the body up and took it away, that he put the body in trash bags, that he made sure the trash was gone and so it will never be found.
So he told
Marquand
someone.
Washington will say, well, how did you lift that guy? How did you lift him, however you got him out of there? And the defendant told him, I was working out at that point. I was so strong, adrenaline. He said, I was like Superman. The combination of adrenaline and my working out was what allowed him to do it.
I suppose.
Marquand Washington tried to get him to tell him, well, why? Why'd you do this? And he said he never really had a real answer, but that one thing that struck him that the defendant told him was, my ex was getting serious with this guy.
Insulin between the toes.
And she was happy. The defendant admitted to Marquand Washington. He also had a girlfriend then, though they are no longer together during the period of time that the two of them stayed together. But he provided those details. So you'll hear about the preparation. You'll hear about the act itself. You'll hear from people who love and care about Rosario Gutierrez, that he is gone.
How long has he been going for?
You'll hear about the physical evidence, and you'll hear about the confession made. And when you combine all of those pieces of evidence, then from the state's perspective, you will have enough evidence and will hold the defendant responsible. Thank you.
Oh, thank you, Christine. Thank you.
Thank you,
That's
Mr.
very
Bradley.
generous of
Let's
you.
take a break.
That's
as
lovely.
I indicated when we broke yesterday, I had some further discussion with the lawyers about some legal issues. And
No, it looks like one of those
I
dolls that the mouse
doing
moves.
some more reading
Yeah.
last night and have come to a decision. I've given them the decision, but I'm going to give them the explanation. So that's going to take a little more time than the usual break. I'm hoping we'll get back together
Right.
in about a half an hour.
Break, skip, 'cause I'm
Please don't
magic.
talk about the case during the break.
And
And
what about there, I reckon. Ta-da! Look, magic. Oh, is that the height of your half on the left there? So it was his ex-wife's new boyfriend.
all right,
So
you may be seated.
he was married to
I
this
hope I didn't hurt
lady
you, folks, but,
chick. I
we
thought they were
decided
just
to defer
dating.
our legal discussion to a little later, and instead
Wake up.
go right to the defense opening statement, and you may proceed.
We boost it. The ex-wife and daughter of victims, this guy, fully freed. They had to live in fear and control. Oh my lord!
Don't have as loud of a voice as the state, so have to use the mic. The essence of this case is actually quite simple. The state just walked you through for quite some time about the evidence and how it thinks it's going to come through during this trial. But at the end of the day, law enforcement nor the state have no idea what happened to Mr. Gutierrez's body. They don't know when exactly anything happened in Mr. Gutierrez's apartment. They have no idea where any alleged remains of Mr. Gutierrez's body is. They have none of that. There are no witnesses that saw my client, Mr. Zachariah Anderson, at 3709 15th Avenue in Kenosha on May 17th, 2020. They have absolutely no witnesses that say, hey, we saw Mr. Anderson and he had bloody clothes or he was acting suspicious. They have none of that because none of that evidence exists. No body, no human remains, no indication of cleaning up a crime scene despite what they state occurred in that van. I'll talk to you a little about that later. They don't have any of that. Yet they decided to build a script, and the evidence will show you this. They decided to build a script and tell a story and make Mr. Anderson the main character, despite the fact that they didn't have any of this evidence. No body, no human remains, no witnesses, nothing. If you're looking in the wrong places and at the wrong people, you are not going to find the information you're looking for. The state just talked to you at length about some of the evidence that it believes is going to come in, and that evidence is going to show you that Mr. Anderson committed the crimes as charged. In the state and myself, he explained to you kind of what opening statements are. I'm not going to do that. You're all capable people of understanding why we're speaking to you right now. But I'm speaking because I see the evidence a little bit differently. And when I'm walking you through the evidence that will come in today, it's not based on speculation. It's not based on some theories that are in my head where there's no evidence to back that up. I'm going to walk you through the actual evidence that will come through during this trial. But let's start with what the state kind of walked you through, that this really all stems because Mr. Anderson is a crazy, jealous, obsessive ex. The evidence during this trial will debunk that theory. And in addition to that issue, motive is not an element of the crime. In order to be threatened by a serious relationship, a serious relationship has to exist. The state talked about how things were getting heavy. between Mr. Gutierrez and Miss Beecham, that they were meeting each other's kids, that there was talk about that. What the state didn't inform you was that Mr. Gutierrez was actively
Absolutely.
dating and seeing several other
Yeah.
women. He was not in any means exclusive with Miss Beecham. He had in fact told some of his closest friends that he was intending on breaking up with Miss Beecham. Miss Beecham had never met a single one of Mr.
Absolutely.
Gutierrez's friends. And this concept of that the state talked about how, you know, she had never talked to her child about Mr. Gutierrez, or that information must have come
Sounds,
from Mr. Anderson. That's not
it's just
that's not accurate. And the text messages that will come in will establish that Miss Beecham had discussed Mr. Gutierrez with her daughter. There were text messages that she sent to Mr. Gutierrez that says, Liv wants to meet your kids before she meets you. Well, obviously, she must have had a conversation with her daughter.
him and his wife had broken up. Did they say 7 years before she met the victim? It wasn't like just a recent breakup. It was a decent time between him and the next one, yeah?
About who Mr. Gutierrez was, but still doesn't change the underlying factor that this was not a serious relationship. Additionally, from February of 2020 through May of 2020,
How long
there was
the
consistent communication between Mr. Anderson and Miss Beecham. And that communication wasn't, oh, I want you so bad, come back with me. It was kind of a mutual agreement that their relationship was toxic. They were never getting back together, that she had guys she was seeing, and Mr. Anderson had his own girlfriend.
Oh. Dirty hose.
The timeline. The state said that the timeline shows Mr. Anderson must have been involved, but the state's ignoring critical evidence as to that timeline. The state admitted May 17th, 2020, Mr. Anderson had his kids, his 3 children. They were at his home in Mequon, Wisconsin. That later in that afternoon, around 5 to 6, Miss Beecham picks them up. Mr. Anderson then, they don't have any evidence that Mr. Anderson left his home. They claim that this is the time where he traveled down to Kenosha, but you'll hear from law enforcement officers that they got surveillance video from multiple places, not only in the Mequon, Ozaukee County area that Mr. Anderson would have had to pass to get to Mr. Gutierrez's apartment, but they also got surveillance from gas stations, schools, the transit authority, from the buses, from neighbors' ring cameras from the area in Kenosha that Mr. Anderson would have had to have passed if he was driving. And you'll hear from law enforcement that they don't observe Mr. Anderson's vehicle. So the state has absolutely, there will be no evidence during this trial that will be presented to you that shows that on May 17th, 2020, when Sadie Beecham is at Mr. Anderson's home, she sees him there. He then texts someone at 11:19 p.m., and you'll hear from law enforcement officers that his phone pings at his home at 11:19 p.m. Nothing shows he ever left home that night. People falling asleep around 7 to 8 p.m. as adults who have children and have been with them all day, that's not unreasonable. So the next morning, he wakes up, he goes to Walmart. You'll hear evidence that Mr. Anderson's a contractor. He was going to a home up in Cedar Grove area that he was working on. He was doing lath removal and other serious removal jobs. It was basically a complete reconstruction of the property.
He probably dumped the body in one of the.
So if he went to Walmart and parked far away, you'll hear evidence that he likely had tools in his van. And in addition to that, he then goes to his job site for 3 hours. And the state's saying that after that, they don't know where he goes. No idea. The evidence will establish that after he was at the house in Cedar Grove for 3 hours, he went to Menominee Falls to pick up his taxes. That's a nice fact that the state didn't talk about that will come in. And what's interesting about the fact that Mr. Anderson had gone and picked up his taxes in Menominee Falls right after working at his job site in the morning is that that evidence wasn't readily given to the defense. That you'll hear that this evidence, this receipt that stated 5/18/2020 from the tax accountant services was a piece of paper that was located in Mr. Anderson's van. And that law enforcement, when they executed the search on Mr. Anderson's property, they took all the papers and put them in a pile and labeled them miscellaneous papers. And they took one
Miscellaneous.
picture of all of those papers, put that
Miscellaneous.
into discovery, and that picture's blurry. You'll see that picture. It wasn't until the defense asked to see that documentation that we saw this
Yeah.
receipt that proved that Mr. Anderson wasn't for hours getting rid of a body, but was going to pick up his taxes in Menominee Falls. And you'll hear from the accountants that he was there. You'll also hear from them that they had video surveillance, that law enforcement, had they gone and talked to these people, would have been able to get that surveillance video to see what Mr. Anderson was wearing, the fact that he didn't have any blood on his clothes. And then after he picks up his taxes, he goes back home and spends the night with his girlfriend, Christine Remsburg.
Yeah.
The next morning, they wake up. It's a normal day. But it's not.
I've got a good one for you. I'm into fitness. Fitness dick in your mouth. Sorry, went there.
Not normal for Mr. Anderson because two random people show up on his property demanding that they speak with a person named Zachariah
He
Anderson.
had
And
carpet
Mr.
hair.
Anderson knows that he doesn't know these people. They don't know what he looks like. So he says, hey, I'm his brother. He's not here right now. What do you want? And they say, as the state noted, we're looking for our missing friend from Kenosha.
Kenosha.
And these people are snooping around his property, acting suspicious. And so what does Mr. Anderson do? He calls 911 himself and says, hey, there's these two random people that are on my property demanding to speak with me. I told them that I'm my brother because I'm a little concerned about why they're here, and they're demanding questions about their missing friend from Kenosha. The man who the state's alleging had something to do with the disappearance of Mr. Gutierrez is calling 911 and saying they're saying that I had something to do with this missing guy from Kenosha. Law enforcement responds to the home, but it's not to respond to Mr. Anderson's concerns. They're there to arrest Mr. Anderson and to execute a search warrant on his property. He's taken into custody. They take pictures of what he's wearing: white t-shirt, blue jeans.
What was their probable cause?
They send some of those, they say, oh, there looks to appear to be a stain on this shirt. Let's swab it and send it to the crime lab. Not blood. No DNA of Mr. Gutierrez. Oh, the jeans, looks like there's another red dot. Let's swab it and send it to the crime lab. No blood, no DNA linking back to Rosario Gutierrez. They took pictures, you'll see these, of Mr. Anderson's hands, feet, arms, not a single scratch, not a single bruise, nothing. So the state's assertion that there's going to be evidence that Mr. Anderson had time to get rid of every single possible piece of evidence, the body, all remains, everything that he used to clean up. The state talked about some items bought at Walmart. They were 13-gallon trash bags and 2 things of Clorox wipes. Don't think that's enough to meticulously clean up a crime scene, nor is there any evidence that that is. Additionally, as you'll hear, this was during the height of COVID. It was basically still almost about to be the lockdown, or actually was in the middle of the lockdown. So searching to see what stores are open before you go to a job site was not bizarre. You'll also hear that during COVID, items such as Clorox wipes and gloves were extremely hard to come by, and you would pick them up when you got the opportunity. So the timeline that the state told you, there's evidence that supplements that shows Mr. Anderson could not have had the opportunity to commit the charged offense. The other piece of evidence that the state talked about was Marquand Washington, and that Mr. Anderson allegedly admitted to him that he did this and that he stabbed Mr. Gutierrez, took his body, put it in some trash bags, and took the trash out and got rid of him forever. The state talked to you a little bit about Marquand Washington. Marquand Washington is currently facing a minimum of 10 years to life, and it's a federal case. And you'll hear during this trial that in federal cases, when there are mandatory minimums, the only way to deviate from that mandatory minimum, so the only way to get less than 10 years is if you cooperate. If you provide information and then get on the stand and testify to that and cooperate, that the government, who's the prosecutor in a federal case, can file a document to say, Judge, we're asking for lesser than that 10-year mandatory minimum. And you'll see that in Mr. Washington's plea paperwork, the government nicely outlines that in order for you to get less time, this is what you're going to have to do.
Oh, well, that's funny. I know someone who didn't have to do jack shit to get a really good plea deal this week. Some 4 felonies dropped. Poof, just like that. And a 910-day sentence for another felony in Florida. How does that happen?
Now, the state didn't mention this to you, but
Correct.
Mr. Washington is someone who will literally do anything to get out of his situation.
Yep.
That they had evidence, that the federal government had evidence that he intimidated the witnesses and victims in his own case in an attempt to get out of his situation. And when that didn't work, he was left with one option: cooperation. And in February of 2022, the federal government was told that he had information that he wanted to share. And they wrote a letter to him and they said, Mr. Washington, we've heard that you want to share some information about some crimes that you have knowledge about in the Milwaukee surrounding area. Please let us know what that is. He did not mention Mr. Anderson in February of 2022, and that's critical because the state said that Mr. Anderson trusts Marquand Washington, but Marquand Washington only was housed with Mr. Anderson for approximately 3 weeks. It was a very short housing situation. And those 3 weeks was from December of 2021 to February of 2022. Or no, sorry, I apologize. It was December of 2021 to January 31st of 2022. So in February of 22, he would have had this information, but he didn't share it then. No, he only shared it about 3 weeks ago in a case that's been going on since May of 2020, when he's allegedly had this information for almost 2 years. But what's even more critical is Marquand Washington, as the state says he will testify, and I'm saying as the state will say he will testify because the defense did not have the opportunity to meet with Mr. Washington. Mr. Gravely, the district attorney, and Vincent Carrera, a detective, they met with Marquand Washington, and they questioned him for an hour and 30 minutes approximately. They did not record the interview. Instead, they gave the defense a 2.5-page summary of what he would say. But what I do know from that 2.5-page summary is that he claims that Mr. Anderson said he stabbed the guy. The officer, the state talked about how you'll hear from officers about the blood stain pattern analysis completed in this case. That officer will tell you that he believed that the stain patterns that were seen in Mr. Gutierrez's apartment were consistent with blunt force trauma. That was his opinion just in February of last year, Officer Van Wee. And in his reports from closer to May 2020, he wrote that he believed it was blunt force trauma, so a heavy object or an object hitting someone. And also Detective Carrera wrote in his reports that it was blunt force trauma. There was never a single mention in Van Wee's reports or Detective Carrera's reports that the stain pattern analysis were consistent with sharp force injuries. There's a difference between blunt force injuries and sharp force injuries. I
wasn't saying that he had bad information. I was just saying that he actually had to become a snitch to arrange a plea deal to have a reduced sentence. And in comparison, what did I have to do to have 4 felony charges disappear?
Injuries is a knife. No mention of that.
Yeah.
In fact, you'll hear that Mr. Gutierrez
was
an avid baseball fan.
I reckon you're
loved
right.
baseball. Not only did he love baseball, but he loved to play baseball with his kids. And he was a coach for minor leagues. And so he had baseballs in his apartment and in his truck. He had gloves in his apartment and in his truck. You know what wasn't recovered in the crime scene?
A murder
Or
weapon.
in a truck? Not a single baseball bat. Not a single one. But the state told you that they had a shard of, the state said it themselves, what could have come off of a baseball bat with blood on it. So the evidence will contradict itself. It can't be the stabbing and it can't be the baseball bat. The next item that the state talked about was the DNA in the van, and the state claims that there will be a witness that will get up here and tell you that that was blood in that van. And I'm not sure where that's coming from. because Lisa Treffinger, who's an analyst at the state crime lab, was the individual in charge of processing the van and that particular dot. And it was so small, like freckle size. She's the individual responsible. And you'll hear from her and other state crime lab analysts that they processed that van extremely thoroughly. You'll see pictures of the van too. Not a van that's been cleaned. There's dirt everywhere, dust on the dashboard, no indication that it's been cleaned, no blood in the front driver's seat. In fact, no blood anywhere. They saw red dots, tested it for blood. They did a test that's specific to determine if a item that purports to look like blood is blood, negative. They did luminol testing.
could have
I
had
don't
a
know if
hazmat
any of you
suit
are
on.
aware of that, but what they do is they spray the substance and it will basically light up if there's the presence of blood. Didn't light up. They said that there was this one flicker of light, so they tested that area, negative for blood. This dot that the state claims someone's going to tell you was blood, in an email from Lisa Treffinger, the analyst that will testify, you'll hear her tell you that the state asked her, an email from the state, I just wanted to confirm that the sample that was sourced to Rosario from the van was blood, right? This was analyst Treffinger's response, and she'll testify to this. We could not confirm it was blood. Her own words, not mine.
So it was
DNA in his
inconclusive
van,
or
though.
negative.
How do you explain that? The state claims that the explanation of how Mr. Gutierrez's blood got in the van was because Mr. Anderson must have killed him. But the evidence will tell you that there's a far more logical explanation for how that occurred. The state talked to you about the evidence that might come in about an incident that happened on April 24th, 2020, where Mr. Anderson had gone into Mr. Gutierrez's vehicle, had taken something out. This was talked about between Ms. Beecham and Mr. Gutierrez at length. Ms. Beecham told Mr. Gutierrez on April 25th about what had happened, how Mr. Anderson had gone in his car. And they talked about how
That must have been when he planted
maybe
the
something should be done about
tracking
that.
device.
There was conversations between them about how maybe Mr. Anderson should get a taste of his own medicine. Later that night, at 11:10 p.m. on April 25th, 2020, Ms. Beecham received a text from Mr. Gutierrez that said, "What's his fucking address?" Sadie responded, "Well, I guess if he has your info, you should have his." And then Mr. Gutierrez sends her a text with Mr. Anderson's address. This is on the 25th. And then on the 26th, he sends her a text that says, "For the record, only if you say it's okay." He also sent, and then Ms. Beecham sends him a text, "He's gonna find out." This all happens on the 26th of April. Mr. Gutierrez is apprised of the fact that Mr. Anderson went into his vehicle. Sadie and Mr. Gutierrez talk about how something should be done similar to Mr. Anderson. And then on April 26th, 2020, Mr. Gutierrez's Cellbrite location data puts him at 6813 Highland Road, Mequon, Wisconsin. He's there. Mr. Gutierrez, after talking about how something similar should be done to Mr. Anderson, that something similar being going into a vehicle, is at Mr. Anderson's house. His location puts him there. And then right after he's there, he has a video FaceTime with Miss Beecham for 2.5 hours. And that conversation occurs at 3:11 a.m. in the morning.
Ah, that was a kinky one. But yeah.
In addition to the fact that there's more reasonable explanations, as you'll see through the evidence, that is ignored by the prosecution, the fact that the timeline illustrates Mr. Anderson could not have done this, the fact that no one puts him there on May 17th, 2020, the fact that there is no blood in the van, there's no body, there are no remains, there's no murder weapon. They still are going with the fact that Mr. Anderson committed this crime. That's because, remember, that's who they chose as their main character. They ignored, and by they I mean law enforcement ignored, legitimate leads and follow-ups, suspicious people. And they ignored that because on May 19th, 2020, when law enforcement met with Sadie outside of Mr. Gutierrez's apartment, she said, my ex had something to do with it. And they said, great, let's run with it. We're going to try to build a case around him, even if we don't have a body. We have no explanation of what happened to him. We have no explanation of where Mr. Anderson would have put a body. We're going to run with him. So what did they ignore? They ignored Miss Beecham.
Okay.
Miss Beecham, as the state noted, went to Mr. Gutierrez's residence at around 11 a.m. on Monday, May 19th, 2020. She had only been dating this guy for a couple months. This guy was dating other people. They only saw each other every other weekend, some weekends that, it wasn't a hot and heavy relationship like the state wants it to purport. The evidence doesn't show that. So she's only been dating this guy for a couple months, a guy she met off of Facebook dating, and decides, you know what, haven't heard from him. I'm going to go to his house in the middle of the day when he would be working to see what's up.
What?
Sure, there could be innocent explanations to that, but you'll also hear evidence that Miss Beecham had constantly been texting with her best friend, Rebecca Jekyll, about how she thinks Zach's tracking her, but can't prove anything. She says that. She says that to Rebecca Jekyll, and she's complaining about it. And this is all on 5/14/2020. She's complaining about it, text messages between her and her best friend, Rebecca Jekyll. And on May 14th, 2020, Rebecca Jekyll randomly texts Sadie Beecham and says, in this discussion string where they're discussing how she, is so irritated with Mr. Anderson, Miss Jekyll sends a random out-of-place text that says, phone call has been placed. All I was told is it will begin and you will not know when, where, or how. Call me in 1 week. And what's 1 week later? When she's at Mr. Gutierrez's apartment. So if we could have the objection outside the presence of the jury.
Go ahead, Ms. Gravely.
Yeah, but
What did you say?
I do want to do it outside the presence of the jury. I apologize. This thread is something that we've litigated prior.
Generally, folks,
Apologize.
quiet, please. I'm going to ask you to step just into the library. If somebody needs to go upstairs, you're welcome to do so, but come right back down. But go into the library, and I don't think this will take long, and make yourselves comfortable there, please.
So the prosecution
Don't
is
talk about the case, please.
objecting to this coming in, the text messages between the wife and her best friend. Felix, come here. Come here. I have a cat with separation anxiety. Can you hear him? Come on. Bloody great sook. Mummy, come to bed, Mummy.
Gravely. I hadn't pressed the button. That's why.
My objection is that the defense line of argument that's just been stated regarding Sadie Beecham is a violation of State v. Denny to be able to name a party and indicate that there are factual circumstances that are consistent with them being guilty of procuring this homicide in the alternative is exactly what Denny was designed to prevent. The court is aware that Denny asks that the defense file a written motion giving all parties notice so that the parties do not, in mid-trial, have alternative actual named parties be described, as well as factual circumstances which are designed to cause the jury to suspect that person is an alternative individual. This is exactly what Denny was designed to prevent. And now the name Sadie Beecham has been associated with this jury with being involved in planning a homicide of this individual, and that's in direct violation. There is no doubt that the defense is on notice as to what Denny is or its expectations. We litigated a Denny motion just last week where they laid out a direct foundation. These are, again, the quoting to the jury are text messages. These are not new pieces of information. And frankly, as I indicated in the prior Denny motion, the court has an obligation as a steward of this information to be sure that all parties are dealt with fairly here. We are required to be able to be provided notice if individuals are out there in that situation and be able to defend those individuals, and the court is required to rule on this beforehand. So I believe this to be an improper argument. I don't think it can be cured at this
You know
point.
why?
And so I asked the court to consider what our remedies are, but I believe that this is a clear Denny violation.
Why does the state not want that to come in?
If I may be heard, Judge. Thank you. In my opening statement, before I started going into this sequence, I talked about how law enforcement did not follow up or look into anything as far as possible other suspects or leads. I'm not offering this. And first of all, I'm just talking about the evidence that's going to come in, right? At this point, this is what the opening statement's for. This is a message string between Ms. Beecham and another witness. This will come in. And it's not to offer it, Judge. It's not to offer it to say it was her. It's to offer it to show that law enforcement did not investigate her, did not investigate anyone else. That's not a Denny motion. I'm not pointing the finger. I'm not saying Ms. Beecham did it. I'm saying they could have followed up on this. They should have followed up on this, and they didn't. It's very different.
First of all, you're telling me it's not coming in. And if it's not coming in, then you're not supposed to talk about it.
No, I said it is coming in, that this will come in through witnesses.
Say it wasn't going to come in.
No, sorry. If
I heard you wrong.
Okay.
Did you want to respond, Mr. Waverly?
Yeah, you can talk about whatever purpose you want. The argument made to the jury is other people should have been looked at. I mean, you couldn't be more clear in your argument. The argument was other people did this crime. My client did not, other people did. Here's example one. And she's now laid out specific electronic evidence that she wants the jury to be presented. So not only is she making an accusation, the substance of this accusation is that Sadie Beecham and a friend of hers have conspired to find a third party who will kill this person. That's the allegation that's been just made. And she's indicating that's what the text would lead a reasonable person to believe. There's been no notice of that specific allegation. The jury has now heard it. It's been shared with the jury. There's a whole body of case law in Wisconsin that does not allow a private citizen to be accused. And for a person to say, well, that's not for the purpose of accusing another human being of murder, that's what she's done. That's the argument that's been made. It doesn't matter if that's not the sole purpose you have. Your objective here is to tell the jury, hey, there's reasonable doubt. Sadie Beecham did this. Look at this electronic message. That's why you argue that. There's no other reasonable argument as to why this has been shared with the jury. And why weren't we given notice of this? Why wasn't, when a Denny motion was filed with all the details, and I complimented the defense just a week ago when they provided their factual circumstances so the court could litigate that with the state, because I believe that's the entire proper procedure. I'm on record as having complimented them
for
supplementing and providing a factual basis for the court to make a fair ruling.
I haven't been on, obviously.
Absence of that in this situation. This can't be remedied. Sadie Beecham has been accused of murder when Denny exists as litigation in this state.
If I may respond.
Go ahead.
Thank you, Judge. I have not accused anyone of anything. I think it's been very clear that the defense is saying that none of this evidence exists,
All right,
and law enforcement.
So who wins the argument? And we'll skip to the next bit. Doesn't even look like the jury comes back in on this video. So we'll go to the next one. Go back to my
control. And so what
had just previously made, which is that that the investigation focused solely on Mr. Anderson. And in fact, the words that she made in terms of what our whole theme and theory of this case is that there was a script that was written. Mr. Anderson was the central player, the main starring role in this script. Now, as in any case where there is an investigation, and if it's the defense's intent to argue that the defendant did not commit this offense, it's part of virtually every case where reasonable doubt is what we're addressing.
So they're still arguing.
Loud enough? Reasonable doubt. I'll try to talk more directly into it. The angle's funny here. So it's really a matter of looking at what the entire investigation entailed. Everything that Attorney Mueller was discussing in her opening statement was based on information that had been provided by
So
the
the
state.
whole of day
Now,
one,
there are a number of different.
this argument. Have a look at it. So we go to day 2.
You've been watching WITI TV this morning.
Oh, looks like they're continuing. Oh,
Anything else?
No.
Nothing.
All right.
Thank you.
Enjoy this magnificent day. First day of meteorological spring.
what? What? There's nothing on there. There's like 2 hours of this. That's it. The fuck? Next. Far out.
Will be read this stipulation, and it's stipulated facts. That means that the jury will be instructed that those are proved facts in the case, and there'll be no testimony admitted either
Right.
to reprove those facts or those assertions, and there'll be no testimony permitted to disprove it. Stipulation means it's agreed. Is that clear?
Yes.
Any question about this at all?
No.
Has anybody threatened you, pressured you, or forced you in any way?
No.
Has anybody promised you anything in exchange for this?
No.
All right. Anything else then before we start?
Just that the first witness,
He
the state
sounds
witness
like
called
it.
Detective Lauren Anschutz, has no prior convictions. And another
So is
witness
this
that
where
we
they
would
pick it
call,
back up?
hopefully without needing an additional break, would be Marissa Swanigan. She's the individual who's here on the warrant. She also has no priors. And so I believe that in terms of these early witnesses that we would call before there would be any additional breaks, that I think we've met our obligation to let the court know about any prior convictions.
Okay.
And we are in agreement with that calculation to the witnesses that the state just mentioned. And as the state said, we'll work diligently in getting the other convictions for the other witnesses to present to the court at a later time.
So let it be written, so let it be done.
Uncharged pickles.
I believe we're ready then, Judge, at
All
this
right.
point. Counsel, do you agree?
Yes.
Call them uncharged piccolos, that the algorithm is going to assign colors, which individual is.
Hang on. I'll boost it. I'll boost it for you so you can hear it.
Inserting some, I'm going to call them uncharged piccolos, that the algorithm is going to
Uncharged
assign colors,
pickles?
which is beyond individual.
Oh. Did you all see that or not? Tell me I wasn't watching it by myself. I did click share screen. Did you see that? Oh, good. Uncharged pickles. Oh, the audio is either really, really low or really, really high. And as soon as I boost it, they start speaking into the microphones and it just about bursts my eardrums. And I can't hear jack shit now.
All right, how did we do that time-wise? Pretty good, all right. Close, okay.
See?
All right, thank you. Go ahead, Mr. Ridley.
Your Honor, the state calls Detective Lauren Anschutz to the stand.
Lauren, what?
Is he out of the room?
He's being brought, he was outside, he's being brought in by our victim witness person.
Okay.
First responder?
I do solemnly swear the testimony you are about to give in this
One
matter.
911
is the truth,
caller.
The whole truth, and nothing but the truth, so help you God.
I do.
Please be seated.
Detective Anschutz, can you state your first and last name and spell both your names for the record?
Lauren Anschutz, LORN-ANSCHUTZ.
Detective, how are you employed?
City of Kenosha Police Department as a detective.
How long have you been a detective?
Approximately 7 years.
And how long have you been a police
You
officer with
like
the Kenosha
this
Police
one,
Department?
Just under 20 years.
During that time period, have you had an opportunity
Sounds
to
really
investigate
pretty.
scenes where blood was present?
Yes, several.
And
like
do you have
this
an
one.
estimate in your 20 years how many times you've come across this?
And this one.
Yeah, eat it, fucker. Eat that shit. Eat that turd.
Ah. Oh, one more.
I'm gonna jacked up on Mountain Dew.
Scene of that
Bad
type and had
boys.
to make some sort of decisions regarding either what to do next or what there was there?
Several hundred.
In that capacity as being on duty as a detective, did you come on May 19th, 2020 at just after 11 a.m. To be at a particular location that you were asked to go to?
Yes, I was told to go to 3709 15th Street for a suspicious incident.
And when you got there, were you the first officer on the scene?
No, there was multiple officers, a sergeant, another detective, and
Would it be would that be uncommon that other officers would get there before a detective for a call like this, or would that be standard that you detectives would not be called in as the first officers to arrive?
yeah, I've never been called first as a detective to respond to any scene. Typically, the officers will respond, make an assessment, talk to a supervisor, and then we will be notified to respond.
And when you arrived, I don't want to know all the details, but what were you in general appraised of? So what were you told in general was the situation when you arrived before you made observations for yourself?
I was told that apartment 1B had a substantial amount of blood inside. It appeared as though there was a major incident occurred in the apartment and nobody was located.
Yeah, what's a Jenny motion? Is that like you look in the toilet and it go and say, I didn't do that. It won me. I didn't do that at all. Bit of potty humor. Potty mouth.
And was that information provided by law enforcement?
Yes.
Were you provided information that the person reporting this was still on scene?
Yes.
And did you have a chance to interact with that individual?
Yes. I
He
spoke
has
with
a
her.
very
Sadie Beecham.
sharp
Okay.
Sadie
voice.
Beecham was on scene. She was sitting in her car at the time I spoke with her.
And did you come to believe that Ms. Beecham had not fully entered the threshold of the residence, had not walked through the residence before calling law enforcement?
Correct.
Okay. So based on that, would your role in this case be to specifically search for a body or somebody
Okay, like,
within that residence, or would that be the
culprit.
role of other people who were at the scene?
That would have been the role of the responding officers to preserve life.
And do you know much about what a downward departure is and how their scoring affects the levels of felony? You have a Denny hearing. At the hearing, you present the evidence that it could have possibly been someone. Oh, okay. Okay, cool. No, I hadn't heard of it either. I like my definition better. I didn't do that.
Make sure the scene is secure.
Okay. And back before you were a detective, were you in that role many, many times
Yes.
over your career?
10 years. Yes.
Yeah.
Okay. And so in that earlier role than yours, would it have been a
It's
priority?
me, my definition of it, what I found on it. Let me see if I can find it, because my computer. What did I save it under? Treehouse Nerd, I think. It's a bit sad when I've got a folder here that says Judge Dipshit. Did I remember what I saved it as. Yes, this one. All right. So what did I come up with? All right. A downward departure. The totality of the circumstances calls for a downward departure. If you only had minimal participation in the criminal conduct, then you may be eligible for a 4-level decrease. But I don't know what a 4-level is. If you were a minor participant in the illegal activity, you might qualify for a 2-level reduction. In other cases, you may be eligible for a 3-level. It doesn't really tell me what the levels are. Participating in a downward departure can get you a lighter sentence, but it also comes with the risk of others labeling you a snitch in prison. During intake, prison officials ask you if you testified against another party. And they do this to ensure your safety. Right, okay. But still doesn't tell me much. Because they dropped the aggravated assault with a deadly weapon, the battery while masked, the aggravated battery with a deadly weapon, and the witness tampering. Oh, a downward departure is a sentence that is lower than what is recommended by the sentencing guide. Yeah, absolutely. In Wisconsin, the judge may sentence to probation. Well, in Florida, they've got this scoring system where they get what's it called? The criminal sentencing. Yeah, the sentencing. There we go. Scoring system that scores enhancements for repeat offenders, blah, 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 blah. So Ty's score on the court minutes was 93.5, and prison sentences are given for scores above 44 points or higher on the criminal punishment code. But I'm not sure if that was his criminal punishment code or not, because when you go onto the Monroe County Clerk's website, that file is still sealed. Oh, cool. You're still here, Brian. First degree to second degree to third degree and so on. So I don't know if you heard yesterday, Ty had, well, we'll go back to the start of this on his court minutes. He had the 5 charges there, and his plea, the deal that they made with him was they completely dismissed the other 4, and they he pled no contest to count 1, which was the robbery with a deadly weapon whilst masked. So they completely dismissed 4 felonies and left the 1 that was a no contest. And so when the judge was actually reading out because we've had the video of the hearing, the judge was reading it out. He was even surprised. He said, "Oh, so this is a downward departure by a non-coerced plea deal." Like, he was surprised. It was coerced, but if you listen to Ty actually rang and spoke with Steve yesterday, he said that it came down to Mansfield and Alvarez had visited him numerous times overnight off the record, in the jail because they knew he was innocent, and Dennis Ward wouldn't let them drop the charges. So that's why that the state agreed and made this deal, because they said he will not back down on taking him to trial. This is your best option, and it was the best way that they could say he was innocent without saying he was innocent, so to speak. Does that make sense? And they not only wiped the $9,500 in court fees, but they apparently wiped over $1 million of fines and stuff as well. But it's all in the telephone conversation, which I will put up as a video if you like, or you can head over to Steve's page and he's got the full phone call there. So it's just unbelievable. Unbelievable. Anywho, back to so if they dropped 4 charges, does that mean it's a 4 level 4 downward departure, or they should have got the yeah. Well, who knows how far up it went, because I don't know, Don. I don't know. But it allows him to then now process all of his civil actions, because he didn't actually plead guilty at all. The hearing took 5 minutes, and yeah, no contest and no objection at all from the state. In fact, they were laughing.
To search for a person and not worry about what the evidence was, or are you already an evidence preserver in that first role that you described?
I don't object as far as leading.
Well, it had an alternative, so the objection is overruled.
Go ahead.
Can you rephrase, or can you
Sure.
give me the question again?
Sure. In that earlier role, is the priority to do the search as quickly as possible, or to meticulously try to preserve evidence, like not step in things, et cetera, et cetera?
In those situations, you're concerned about the safety of others. That's your main focus and priority at that moment, as well as scene security. We don't know if anybody's in there. So that's what you're vigilant of when you first enter. And then obviously after, you can slow down and then focus more on the preserving of evidence.
So I want to turn your attention to the address one more time. You said it was 3709 15th Street, apartment 1B. Do I have that correct?
Correct.
And do you know, is that a part of a complex, or is that an isolated single-family location?
So it's a larger multi-building apartment complex. I believe there's 3 or 4 different addresses per building. 3709 is mid in the middle of one of the buildings, with an entry door specifically to that address on both the west or north and south entrances of the apartments. You can enter either side. Once entering, there's 4 apartments downstairs, 4 apartments upstairs.
So this specific building that you're speaking of so far has 8 apartments. Did I get that correct? 4 up and 4 down?
3709 15th does have 8 apartments, yes.
Okay. And you are focused, of course, on one apartment of those 8. Is that true?
Number 1B.
Okay. Is that location, is that overall complex, does that have a name here in Kenosha?
Yes, called Wood Creek Apartments.
Okay. And is that address specifically in Wood Creek Apartments, that 3709 15th Street, is that in the city and county of Kenosha?
Yes.
And in the state of Wisconsin?
Yes.
And where is 1B in relation to the other apartments in the building?
It would be the northwest apartment. So of the 8 apartments, it's on the first level, northwest apartment.
So it's first level. And is it closest to the main doors that face the parking area on its side?
Yes.
Okay. And then there would be a second floor of apartments?
Correct.
So if I understand correctly, 1B would have an apartment directly above it?
Correct.
And it would have an apartment across from it?
Correct.
And then it would have an apartment on the side of it as well?
Yes. So the way yes.
When you were there that day, what can you say about the weather conditions that were being experienced?
We had received a substantial amount of rain, so everything was wet. It was gloomy, cooler.
You say substantial amount of rain, just a Wisconsin short rainstorm or something larger?
No, it had been days of rain.
And had that rain been going for multiple days before you arrived at the apartment on the 19th of May?
Yes,
Heavy rain.
a substantial amount of rain, very
Okay.
heavy.
Thank you. So when you got there, Detective, you arrived, there were already officers on scene. You indicate you speak to a person who identifies herself as Sadie Beecham, and she's located by her car. Is that correct?
That's correct.
Is it still raining outside in your memory?
I don't recall. I know it wasn't a downpour. If it was raining, it may have been sprinkling.
Okay. And at that point, what, if anything, did you notice about the demeanor
what, if
of
anything?
Sadie Beecham?
Where's Lally?
She was scared. She was visibly shaking, having a difficult time spitting out words, frightened, worried.
Could you tell what she was scared about in general?
I'm going to object speculation.
What, if anything, led you to conclusions that she was scared other than these early physical observations?
I'm going to object again as to speculation to how his conclusions that she was scared.
Talking objections?
People don't talk the way lawyers want them to. Lawyers are taught that the witnesses are to testify only to things that they perceive with their senses. I saw this, I heard this. That's not the way people converse in ordinary discourse. They combine their observations with the impressions that they personally have formed, which do often involve some degree of speculation, and sometimes involve making suppositions about what others are thinking. That's not how we talk in ordinary discourse. But when we get into the courtroom, the lawyers want to pin it down to exactly what the witness personally knows, what the witness has, and somewhat the conclusions, and they're there. So I'm actually going to allow some supposition built in.
Physical observation that she appeared frightened.
Yes.
Any other observations or information lead you to conclude she was frightened other than that physical observation you've testified to so far?
Yes.
And what was that?
She was concerned about her children.
I'm going to object. This answers hearsay.
It's supposition.
I'd briefly like to be heard.
Well, I didn't say.
Okay.
Now see, I'm supposing what you're thinking.
I believe you are. I believe you are.
I'm right.
Yep.
And we can have that discussion separately if and when you ask the question. But in terms of this particular question, it is not that it's hearsay, it's supposition. So I'm going to sustain the objection.
All right. I'm going to head the direction you are anticipating now then, Your Honor. So, Officer, at the time that you first spoke to Sadie Beecham and she provided you information, was she physically shaking?
Yes.
And did she show signs to you that she was still experiencing emotion as she was speaking to you about what she was telling you?
Yes.
Was it, would you describe her way of expressing herself as calm or excited or what would be your explanation of the phrasing and wording and tone of her discussion with you at this stage in your contact?
It's a beautiful day here today too.
Truly scared of, petrified about what had happened.
Judge, I'm going to indicate to the court that this is an excited utterance and ask the court to allow admission of anything that was during the physical observations he's expressed.
And Judge, I would object. This witness has already testified that he was not the first individual on scene, so that there were other individuals who had spoken with Ms. Beecham prior to this. Several time had passed. Also, excited utterance has to deal with that immediate impression. Nothing was ongoing at that time. The defense would maintain that given the time that had passed and the time that had passed since she had made these observations, any subsequent statements made to Detective Anschutz, it does not fall under the excited utterance exception to the hearsay rule.
Well, let's begin. First of all, it's not my impression that they're actually being offered to prove the truth of what is asserted in the statement. I don't think the district attorney is offering this proof the content of the statement, which is asserted. Second, it's a non-testimonial statement, so we don't have that concern. And to the extent that it would qualify as a here's definitionally hearsay statement, it is, I think, an excited utterance. The law with respect to excited utterances, the key is
Come on,
not,
Judge.
for example,
Get
the
it out.
passage of time or the intervention of others. It's the spontaneity of the statement which is made. And given the situation that existed as portrayed in the testimony, I'm going to overrule your objection.
What did she?
I guess the couple things, Judge, just if I maybe heard. First, we haven't heard what the statement even is. That
Yeah, that's correct.
And second, if the state's premising their question that they're seeking to introduce the statement under the excited utterance hearsay exception, then they must be offering it for some sort of truth, or else they wouldn't need a hearsay exception.
Well, you're right, and that's why I let off actually starting with the confrontation, or actually I actually started in my analysis with whether it's even subject to those rules, because it's excluded from the operation of the hearsay rule. So I would not even accept the premise that he needs an exception to get it out of the hearsay rule. But I understand your point, but I'm going to overrule the objection. Go ahead.
So my question is, what did she say to you when she was in the condition you have described?
She had told me she got to the apartment, observed the screen door closed, but the glass door opened. She looked inside, saw blood everywhere, and walked out. She said she was frightened for her children because she knew Zach Anderson had something to do with this. And
Judge, I'm going to
she's
object at this point and ask that be struck.
Judge, this is all during what she said during the exam. She's going to testify. This is subject to cross-examination. The officer should be allowed to finish saying what she told him on the scene in this excited state and not be interrupted unless there's a new objection. The court's already ruled that in that state, she can say this.
Well, I've ruled that when she's in this state, she can state things that would be normally reactive to a situation in which she found herself, but now she's getting into her analysis. And there's actually another rule, which is the present mental state, the purpose or plan, which probably would give some relief to the district attorney. But the problem with the testimony is it's reaching into the ultimate facts of the case, and it is relayed testimony for a witness who's available to testify. And correctly, you state she's going to be subject to cross-examination, but it's not as it's her opinion about the what she's concerned about is inadmissible. It's irrelevant what she thinks.
I'm just reading your Discord messages, Udahef, and you're right. That the fact that I was getting at yesterday was that and I came up with that bumper sticker about, Massachusetts versus Key West, and the difference is pretty much one letter, Reed versus Reed. So I also thought it's a Y chromosome as well. You're putting up an attractive woman who is well educated and wealthy against Ty, who has a history of drug use and and whatever, and perhaps a criminal history, and was deemed homeless at the time, which he wasn't. And you just see, like, you Google now on YouTube, Franklin Tyrant and Tucker, and you see how many hits you get on YouTube. And then you type in Karen Reed, and you see what you get there. And unfortunately, the visual aspects of defendants does get taken into account, and it is wrong. It's wrong. It shouldn't matter what you look like, or how much money you've got, or what nationality or sex you are. It's supposed to be a fair and equal, non-biased system of justice. And yeah, but I agree. I haven't studied this, as I said, I haven't studied this case at all. So it seems like it is very Karen Reed orientated, in that you're either guilty or not guilty. There is no grey area. So, but leave it with me. I will let you know how, if they get their reasonable doubt, if they convince me.
She expresses a alarm to officers.
Yes.
I think that typically a person who has observed a crime scene is allowed to tell an officer.
I don't want to talk about typical.
Oh, okay.
Okay.
Well, so in this case, she arrives at a crime scene. She has an abundance of evidence that, of course, is not in this case so far, right? But she has an abundance of information. She is in a highly frightened condition, according to the officer, and she expresses fear for her children because of something specific. I don't think any of that's irrelevant, nor is it hearsay.
The problem is that, starting with the testimonial nature of it, it's still not. But we're getting to the point where you're getting into what should come in, if it's going to come in at all, as testimonial. She's not subject at this point to cross-examination. So I'm going to sustain the objection.
After she expressed fear for her children, what happened next in relation to Sadie Beecham?
Due to her concern for the children, she
We've got to move on to the next step, because he's incorporated the objectionable material into the beginning of his next answer. So just what happened next is the question.
Sadie left to check on her children.
And after that, did you then take it upon yourself to be part of an entrance into the residence?
I did.
Okay. Up until that point, what had you done in relation to the residence, if anything?
I peered in the sliding window, didn't enter. And I also walked into the hallway through the front entrance, and looked around in the hallway.
I'm going to now show you what's been marked as Exhibit 1 in this case.
Exhibit 1, Photo 1.
State's Exhibit 1, Photo 1. It's going to come up on the screen up there. I'm going to ask you if you recognize.
Judge, I'm going to ask that it not be published for the jury before it's been admitted, that it needs to be shown to this witness first, not in front of the.
Well,
Let me talk to counsel briefly about that.
Okay,
so that,
and I will
so that
say-
she understands at least what I'm talking about.
okay, and based on the electronic experience we've been having this morning, it may not show up on the screen anyway.
That's rude. I'm in the middle of sending a message. Come on. He looked like he was doing a duck move then.
Her objection, but she's first asking that I read a stipulation. This is a stipulation that we have previously provided the court, and it's about the admission of evidence that comes in either pictures or downloads.
Oh,
I have your permission to read that stipulation.
Did someone eat too much? And have a nice sleep in today? Good morning. Oh, absolutely. And yes, yeah, we're all entitled to our opinions, and absolutely keep them respectful. Shocked to learn anyone was defending him. Yeah, well, I mean, I was watching, because as you know, I've got Nick Starrow coming as a guest on the podcast on Saturday, and I had no idea what this case was about, and he was discussing it with a couple of other attorneys, Ian Runkle and another one, I can't remember, but Nick Starrow was or is heavily involved in fundraising for Zachariah Anderson's appeal, apparently, because he's adamant that he's innocent. And Ian didn't know anything about the case, but the other attorney that was on there on the weekend, he had like a panel show on Saturday night. And yeah, they weren't harping on about it, but yeah, they were both of the opinion that he was innocent. So I've heard a lot of people say either way, but I haven't heard the facts or anything like that yet. So I'm keeping an open mind. But yeah, it's very divided, and good to see you, Tricia. Black Friday shopping, yes. Oh, there's some cheap ass flights from Melbourne at the moment, like to Thailand. Like, yeah, really, really cheap. And I was so tempted, and I didn't do it. Oops.
Relation to the court.
You may do so.
So this says the below signed party stipulate. It's signed by both myself and Attorney Miller. It indicates the below signed party stipulate that all photographs, financial records, phone records, social media records, computer downloads, and phone downloads be admitted into evidence without foundation testimony. The purpose of this stipulation is to allow all parties to discuss and question witnesses regarding these records without having to previously set a foundation. So essentially what we are doing, Judge, is we're stipulating that, oftentimes in a courtroom, we have to bring in somebody to say who took the photo or how was the photo compiled. There's additional witnesses or additional time. We're just going to seamlessly show those records as long as we make sure each other are apprised to try to save that time, because there's an enormous amount of records and photographs, as the court is aware. Is that true, counsel?
That is true, and I just thought it was appropriate to read that stipulation prior to it being shown to the jury, so there was that understanding and the record. But any objection to it being shown now is withdrawn, now that that stipulation's been read.
Thank you. All right. Best.
Again, I'm going to show, Detective, I'm going to ask you to turn your attention to the television that's above the jury and look at State's Exhibit 1, Photo 1. Assuming that it works. Judge, does your laser pointer work onto the television?
It doesn't work on the glass.
Okay.
But I do have.
Do you have the old school?
I have Sister Marcienne's. Where is it?
Oh, can you?
Many's the time. It's not going to come on? Oh.
Okay. Just works perfectly and seamlessly, Judge.
Yes,
Yeah.
indeed.
All right. So
If he's going to be using the pointer, maybe we'll give him a mic. Let's hope we've got power in this.
So, Detective, as you look at this, do you recall what this is a picture of, or know this picture contemporaneous with what we've talked about, May 19th, 2020?
So this would be a picture of the north side of 3709 15th Street from the parking lot, looking at the entrance to the residence.
The residence we've talked about, apartment 1B?
Correct.
Can you tell by the conditions of the vehicles and the roadway there what the weather conditions are at the moment these pictures are being taken?
It's either raining or had rained.
Is there? Do you see a white larger vehicle that's prominent in the center of picture one?
Yeah, should I point?
Yes,
This one?
I'm referring to that vehicle. Do you recognize that vehicle in the context of this investigation?
I do.
Okay, and what is that vehicle?
That's a white Ford Explorer, Colorado plates. That was belonged to Rosario Gutierrez.
Okay, and is that the individual who you believe to reside in apartment 1B?
Yes.
Is Rosalio's sliding doors, in other words, a non-hallway entrance to his apartment or exit to his apartment, is that visible in this picture?
Yes, it is.
And can you point out where that is located within this picture? Okay. There appears to be a yellow sort of tape or rope that is located in this picture as well. Do you see that?
Yes, that's crime scene tape.
Okay. Is that in a couple of locations in this picture?
Yes.
Can you point out again with your pointer where that is?
There's some here stretched, then some up from the entry door to 3709 stretched out towards the parking lot.
And based on your knowledge of these investigations, who put that up in general?
Usually the responding officers will area off so no one comes or goes.
This is after they make their initial assessment of safety and security?
Correct.
Okay. And so at the point that you have finished speaking to Sadie Beecham initially, is this the vantage point, or is this the view you are seeing back on May 19th?
Yes, that's accurate.
I'm going to show you now what's been marked as picture 2 of Exhibit 1. Do you see that picture as well and recognize that?
I do.
What is that a picture of?
So this is the main entrance to 3709. This would be the sliding screen door, glass door to apartment 1B, which is just inside the door to the right.
And do you recall whether the overall building that where you see this door here, is that a locked door or is that an unlocked door to get into the main hallway?
That is unlocked door. There's also a door on the other side of the building that you can enter this hallway that is also unlocked.
Okay, so at this period of time, this apartment complex did not have locked doors into their central hallway.
Correct.
And what would you estimate is the distance from the Rosario Gutierrez sliding door that we can see there onto that small patio, and then down to a vehicle parked directly parallel below? How many feet would you say that is, or however you want to estimate the distance?
25 to 30 feet.
Okay. And much of it is grass?
Yeah, there was a small concrete stoop and the rest grass, then sidewalk.
And of course, concrete. The sidewalk and the patio would be probably concrete.
Yeah.
All right.
Yes.
Now I'm going to show you what's been marked as Exhibit 3. Again, is that something you recognize again from May 19th, 2020?
Yes, this is going to be the front entrance door to 3709 15th Street. This would be the sliding glass door to apartment 1B.
So it's a different vantage point, a little closer up.
Correct.
Now I'm going to show you what's been marked as Picture 4, Exhibit 1. Do you recognize where that is located on May 19th, if you do?
Yes. So when you enter that main entrance door that you just saw in the last photo, there's a stairway leading to the upper section of the apartment complex, and this would be immediately to your right underneath the stairwell. This is the door to apartment 1B.
So as I look at Picture 4, can you orient me on either direction where that front entrance hallway to the hallway is? Is it further down the hallway, or is it off to the, I guess would be the right of the exhibit?
I'm sorry.
The main doorway we saw in Exhibit 3 that takes you into the hall.
Okay.
Where's that located vis-a-vis this picture?
So this photo is taken just inside that main entrance to 3709.
Okay, so essentially this is taken in the doorway of the entrance we saw in Picture 3?
Yes.
Okay. And so how many feet, again, would you estimate it is to go from that doorway entrance to the doorway of 1B?
10 to 15 feet.
Okay. And there's a stairwell there?
Correct.
If a person wished to, could they ring the doorbell or knock on the door at 1B and be able to stand or crouch to one side or the other of that door? Is there room to do that?
Yes.
And where is there room to do that depicted on this picture if it is?
So this is a small hallway or a small wall that extends out. If you were to go around to the other side of this, you wouldn't be seen. You also could back up to where the photo was taken and not be seen. And also there's a void here underneath the stairwell that you could stand or crouch under the stairwell and not be seen.
Are the metallic objects to the right of the door depicted on this picture, are those mailboxes?
Yes, those are the mailboxes for the 4 lower units. These are for the 4 upper units.
And based on how high up the stairwell is, if you can estimate, does a person have to sit down to be able to get to their mail, or if by bending or standing, are they able to reach their mailboxes in this picture?
Now you're able to walk up to it and get that mail.
If you know apartment 1B, does that door open, again, only if you know, does it open into the hallway or into the interior of the apartment, if you recall?
It opens in to the apartment.
So, and did it have a doorbell of some kind, if you recall?
Not in the hallway here.
Okay. So if a person knocked on this door
Play the piano.
and then did not become visible, is there one of those eye holes so that from inside you're able to see into the hallway?
Yes, there's a eye hole.
Okay. So if you kept yourself off to the side so you were not visible in the eye hole, the door opens back into the apartment if somebody is inside and they are opening the door to see who knocked. Is that correct?
Yes.
And until somebody peeked out, in other words, brought their
Can you not
head out of their
yell?
apartment,
Just
they would,
normal
that
inside
area by the
voice,
mailboxes
please.
would not be visible to them
It's 2
until
a.m.
they somehow extended their head out into
2:30.
the apartment
Inside
or
voices.
took a severe angle after opening the door. Is that right?
I'm going to object as far as foundation, this witness's knowledge of whether that's possible and whether he
Leave
attempted
now.
to do that himself.
I think he can make estimates based on his observation and how the door works. I mean,
He didn't
he's a
leave enough
physical observer.
time.
He's an eyewitness.
Oui, oui.
I think it's
Oh, Sherry.
subject to
Merci beaucoup.
analysis as something that he can perceive without any particular expertise beyond that of the ordinary.
This is a really,
layperson.
really boring one.
But it's,
Sorry.
his description of it makes it more,
His face.
makes it easier for the jury to understand. Objections overruled.
Did you understand my question?
Go again. Sorry.
Sure. If somebody is crouching or attempting not to be seen and they're in the area of the mailboxes, okay, and they knock on the door and the person inside 1B opens that door.
Oh, that's right. I saw the picture of. Who showed me the picture of this? That's inside the stair, under the stairs where the letterboxes are, and it was fully lit up, or something like that. Yeah, I think that was the picture I saw.
To be able to see somebody over by the mailboxes, would they have to poke their head out?
So I would say you would have to break the threshold of the door. We train on clearing room clearing in law enforcement. And in order to see up against this wall, we have to break the threshold. That's one of our main concerns when we clear rooms before we enter them, is a blind spot up against the wall right here. We can pie the room off all we want, but we can't see this. Even if we're standing way on the other side of this door, looking on an angle, we can't see against the wall. And that's our main concern when we enter rooms, because we can see the whole room except for tight against the wall.
When you say clear a room, does that mean to try to figure out if there's danger to you in that next room?
Correct.
And would that danger include a person having a weapon?
Yes.
And do weapons include everything from guns or knives to clubs or hard objects that could hit you?
Correct.
Okay. So when you clear a room, you're worried about all of those possible threats in the possession of a person who might be crouching. Is that right?
Yes.
So
Tiger,
did you,
one dragon.
before you entered the rest of the apartment, were you able to make observations that concerned you at the location we're talking about? In other words, then the door and the hallway that we're in right now. Were there observations that you, as an officer of this extended period of time, having been to scenes with blood before, did you make observations that concerned you before you entered?
Yes. I see what appeared to be blood here.
Going on, I can feel
That
it.
blood was
Feel it in
running
my
down the
water.
wall,
Something's
down the
happening.
door frame.
Judge, I guess I'm
On
going
the
to
wall.
object to his answer saying that it's blood.
He didn't say it was blood. He said it appeared to be blood.
you know, Judge, this is a person whose credibility on this issue is that he's been to what he told you was hundreds of crime scenes over a
Well,
period of more than a decade.
we're arguing about something that's not up because I didn't.
Yep.
The witness did not say it was blood. The witness said it appeared to be blood. So you're safe.
Okay.
All right.
Should I go on then?
Be my guest.
Thank you. So,
Crouching,
excuse me.
but I'm crouching.
Officer, did you see anything else that caused you concern at this specific location in those early observations?
Yes, there's blood, what appeared to be blood on the door. There was also what appeared to be blood on the mailbox, the wall of the door, and the mailbox.
And then ultimately, did you enter the crime scene?
I did.
And do you recall what way you entered the crime scene? We've seen two entrances, the hallway and the sliders. Which one did you go in, if you remember?
We entered through through the sliding door.
Okay. Do you recall when you ultimately, if you know, do you recall whether this door was locked from the interior or not? Only if you recall.
Yes, this door was locked from the interior.
When you arrived at the scene?
Correct.
Okay. So when you entered, did you take any steps to try to be a steward of the evidence that was in any evidence that might be involved in that scene?
So at the time, it was the utmost importance preserving evidence on the scene. I wore booties over the top of my shoes. I wore a mask. I wore gloves. I didn't have anything with me. I was super cautious with transferring evidence.
So when you walked in, do you recall who went in with you, if anyone?
Detective Correa.
Just to stop you, is Detective Correa the individual seated in the here at council table with us?
In the gray suit.
Okay. Who else, if anyone?
Officer Widener and Officer Van Wee.
And do Officer Widener and Van Wee have a particular reason that they would be accompanying you within the Kenosha Police Department? Are they detectives?
No, they're highly trained in processing evidence. They're specialized in that, retrieving evidence.
So let me just ask you, to the extent you know, that's a specialty in a police department
Yes,
that requires an additional training, extra training?
large amounts of training.
And do you know, if, in your experience, our officer, did you say Van Wee?
Yep.
And Widener, are these brand new officers who have just started the evidence collection, if you know?
No, they're both seasoned officers who've been on longer than me, 20 years. And they have been processing evidence scenes for the vast majority of their time at the police department.
Is that why they would be sent to a scene like this one, in your opinion?
Correct. They're the best we have.
Okay. So why are they, was it a surprise that they were coming in with you, or does that make sense to you in the context of what this investigation is? Describe for the jury how come there are 4 officers coming in now. We know some officers have already been in there. They have a different role. What's going on now?
So we walked in, Detective Cree and I were the investigators on the case. Van Wee and Widener were there specifically for evidence collection. So while we were in there, we communicated with each other what we've seen, thoughts on what happened. And ultimately, you know, we picked up on things, they picked up on things, and then they completely, thoroughly process the scene.
If I said that this sounds like it was a walkthrough, is that a word, a phrase that you're aware of, or a term?
Yes.
And is that what
Nothing,
you just...
nothing was collected at that time. We simply walked through to get an idea of what had happened there to further our investigation.
So if I understand, it's not your role to pick up individual pieces of evidence. Is that right?
No, that would have been entirely up to Widener and Van Wee.
You're making observations to see what to do next.
Correct.
Okay. Do you observe any electronic items that are on that would at least cause you to note that in terms of, you know, why this scene would be where it is? Were there any electronic items on?
Yeah, there's a large television that had a blue screen with Rosario, the name Rosario.
I'm going to show you what's been marked as Stakes Exhibit 150 and ask if you recognize that. This is, again, Exhibit 1, Your Honor, Picture 150. I apologize. I'm always mean, if I say 150, I mean the Picture 150.
This is the television.
Yeah, I'll continue to say it. I'm just going to keep forgetting it. Yeah. So Exhibit 1, Picture 150. Does that depict what you have just described?
Yes.
All right. And so that's a television, I assume, that we see that has the blue screen?
Yes.
Okay, and you indicated it had Rosaleo. Can you just point that out with the pointer, please?
Yeah, it appears to be in like a standby mode.
Okay. Now, it looks like the TV screen is above a cabinet or shelving that is fairly extensive in
my
the room. Does
God.
that appear to be an
In my head.
accurate depiction of what you saw on the 19th?
Yes, this was on the west wall of the living room area.
All right, and I'll show you a diagram in a minute, have you point out where on the diagram. But before I do that, is there any evidence that anything has been disturbed in this? It looks like, I mean, is this a cabinet or is this a bunch of shelving, or do you recall? If you know.
Both, I guess. I mean,
Okay.
it's cabinet with shelving, like an entertainment
Okay.
stand, have you?
Does it look like any items have been toppled from this or are disturbed in any kind of major way?
Make it stop.
Not majorly disturbed. However, there were some items laying on the ground that may have been knocked off that. I don't know.
And were there any, as to this cabinet or this set of items, if you recall, did you make any observations about anything on this item? Only if you remember.
Yeah, there was blood spatter on the photos, photo frames, basically throughout.
Okay. All right. I'm going to show you.
Judge, again, I'm going to ask that that be struck as far as that it was blood splatter.
There's not a foundation for the witness to identify the substance which he observed as blood. So unless I'm corrected, we're going to interpret that as it appeared to be.
Appeared to be blood to me.
Okay.
Judge, I just would like to approach just briefly. We can just talk about this very briefly.
As you wish.
Okay. Blood. There were some droplets there. You're not saying that you are aware that there's been some professional confirmation that it was blood. Is that correct?
That's correct. It appeared to be blood.
Okay. So when you say blood in this context, you're stating your opinion as a professional police officer based on your training and experience. Is that correct?
Correct. For now on, I'll say appeared to be blood.
But you're not saying that you did any kind of professional analysis. You're simply saying, based on what I do for a living, I'm offering you the opinion that's blood. Is that true?
Yes.
Okay. So I'm going to show you a diagram of.
The opinion that it appered to be blood. And I would add what I said before about people in ordinary discourse had some degree of supposition and personal, or not personal knowledge, but historical experience into their answers. So if he does slip into saying blood, keep in mind that is not definitively proved. He's saying, okay, think further during the trial. So
This requires us to change machines, Judge, so we just need the patience of the jury. So
It reminds me of a car salesman. He does. That smile.
as far as it goes, okay.
Yeah, no, he's nothing
all
wrong with
right,
the car. Runs beautifully.
Please take a close look at Exhibit 41 for us and indicate if that appears to be a diagram of a layout,
It seems to
yet
be.
not to scale, that you recognize.
Yes, it's a very rough sketch of the apartment.
Does it appear to be basically accurate based on what you recall of your walkthrough at the residence at 1B?
Yes.
So on Exhibit 41, can you just point out for the jury, where is the hallway door that we saw?
It'd be right here.
Okay. And so when you enter that hallway door, what is on each side of you? So what are the first things that are on either side of you in the apartment as you enter? If you remember.
Oh, that's a good.
Coming through this door.
Yep.
That's a good scale drawing, isn't it? Should have been an architect. This is the sliding door he's talking about. So I'm tipping it's this bit here. That looks like the kitchen. Can't even read his writing.
The hallway door.
So to the right, this way would
Yep.
be, there was a couch.
Okay.
Um,
And does it appear to be an L-shaped couch?
Like
yes, it was an
one.
L-shaped couch.
Okay. And then what else?
There was a mat
Yeah.
standing up. And and then to the left was a kitchen area. But I recall there being a wall or something here. I'm not 100% certain.
Okay. That's what happens when you first enter, correct?
Yes.
And is there a dining room table area?
Yes, this would be the kitchen. This would be the dining room area here, dining room table.
And the rest of that then, including where the couch is the living room area?
Correct.
Okay.
This whole area would be the living room area.
Where's the TV that we just saw located on this diagram?
Against the west wall.
Okay.
On the west wall.
And then where are those slider doors that we just saw that would bring you out by the street?
So the slider entrance is right here.
Okay. So when you entered, you said you entered the slider door, correct?
Correct.
And then if you enter that door off to the right, you see the TV that we already showed a picture of, correct?
Correct. The cabinet and the television photo that you saw would have been taken from similar to this.
All right. Okay. Now, you're not the evidence person, so I'm not asking you for specific and sort of honed in detail. But as you enter the slider doors, what is it that you observe that causes you concern, if anything?
So as soon as I walked in, I observed.
What if everything was there a stove?
Substantial
in there?
amount of blood right here.
Located on what?
So it would have been on the carpet, pooling of blood.
What if anything was there a gas appliance?
So within that pooling of blood, there was an obvious void
In your
where
experience,
there was no blood
cabinetry.
in the shape of a rectangle. So substantial amount of blood right here, and then a void, as if there was like a rug there that had been moved after someone was bleeding.
What else did you observe that caused you any concern?
I observed a significant amount of suspected blood on this table, on the couch, on the walls, on the ceiling, on this wall,
I think
on the cabinet,
so full of fluid.
on the floor throughout here,
Skin stretched so much.
on the back wall,
So,
and some areas in the kitchen here.
so detective, you sound like you're describing
Stupid
many
apparatus.
locations in multiple rooms. Is that what you're intending to tell us?
Stupid crushed vertebrae.
There was suspected blood throughout.
Okay. And some of that's on the ground,
Yes,
and some of it on the ground is substantial.
yes,
Okay, a lot.
yes,
And some of it is on the walls,
yes,
and it's not just one wall; it's several walls in the residence.
Yes, you've established
Yes.
that.
And some of it's on the ceiling,
Inside
Yes.
voice.
and it's on the ceiling in several areas of the residence.
yes.
What about the couch area? Did you observe any blood in that area or anything that, I'm sorry, again, that in your opinion was blood?
Yeah, so the couch had.
What about the couch area? Could you observe anything with blood? Could you put up with me doing this all
droplets
trial?
of suspected blood throughout it. However, against the backrest of the couch, right about here, there was a large amount of blood up where you would put your head, up towards the top of the rear cushion of the couch. Right here.
Well, he looks
Okay,
grumpy back there, doesn't he?
Do you,
Turn that frown upside down.
let me ask you about some specific pictures now and just orient me as to the diagram. So you mentioned a couch and you've pointed out that's the L-shaped object. Is that correct?
Uh-huh.
Yes, right here.
Okay. And then you mentioned that there was a table and a wall area that was over close to where the kitchen area starts, correct?
Mm-hmm.
Over
Was
sort
there
of
a
across from
light
the couch.
switch too?
So now I'm going to show you what's been marked as State's Exhibit 155.
Laugh. That's a cough. Those captions can't even get that right.
55?
State 1, number State 1.
Yep, no,
55,
that's fine.
not
You're
155.
What girl? Had a ponytail.
So based on your observation of the scene at 1B, do you recognize this picture as
Oh.
something you observed in the period
Oh, yes, I see the
on
map-
May 19th
that
when you
one.
were in the residence late morning, early afternoon?
Yeah, that appears to be taken right as you enter through the sliding door. Yes.
Okay, so is there a door depicted in photo 55?
Yeah. This door right here would be the door that enters into the hallway.
And then you indicated there was a couch and that you recall a wall and a table. Is the wall and the table that you recall depicted in picture 55?
This wall,
Okay.
there's a small table.
Okay. And was that an area of concern for you in terms of your
Yes,
observation?
he is.
Yes.
Why?
There appeared to be a substantial amount of blood on it.
The cleanest
Then
fingernails.
I can see some areas that appear to be staining on a carpet or rug. Do you see the areas that are depicted on this picture? Okay. Now, you indicated in your testimony there was an area on the floor that you saw a substantial amount of what, in your opinion, was blood. Is that an area depicted in Exhibit 55?
I had mentioned the pooling of blood on the floor. This is the pooling of blood I was talking about right
You
here.
never want to
And
outshine
there
the
are
guard
other
either.
reddish or brown stains at many locations on this carpet. Is that consistent with what you saw that day?
Yes, it was everywhere.
Okay. And do you have an opinion as to what that was in the context of everything else you saw and know from this investigation?
It appeared to be blood.
Now, you've indicated a couch, L-shaped couch. Is that
It said
depicted in
that.
picture 55?
Yeah, so this is going to be the front side of that L-shaped couch with the back of it coming out this way. That makes
And if we go to the right side of this picture, okay, so past where the bike is, where are we in the house or the apartment at that point? Just to orient us.
So directly to the right of whoever took the photo is going to be the television
Okay.
stand. And then there's a hallway right here that leads down to the bathroom and bedroom.
Okay. So we haven't talked yet about the bathroom and bedroom, and that was on that diagram. It's on the other end of that apartment, correct?
Correct.
Was there anything that caused you any concern that you remember in the bathroom?
No.
How about in the bedroom?
No.
Was there only one bedroom?
Yes.
Okay. So those two areas appear to you to be untouched, as best you could tell?
Clean. Yes.
Okay. Now, I'm going to turn your attention from Exhibit 55 to number 220, picture 220. Is 220 a vantage point or a picture that you recall from the 19th of May?
Yeah, so this photo would be standing over top of the L-shaped couch with one side of the couch going this way, the other side of the couch going this way. When I mentioned what appeared to be blood on the back cushion, this is what I was talking about.
And how would you characterize that? Was that just a small amount or a substantial amount? What in
No,
your opinion, what is that?
There was a substantial amount of blood. This wasn't just a spray.
Fallen backwards onto the
It
couch.
was a large amount of blood.
His
And
head
then what
on
is the
back
object that's
there.
located on that couch that we can see sort of in the center of Exhibit 220 or picture 220?
So that's a wallet.
And pursuant to your investigation, did you come to believe that that was Rosario Gutierrez's wallet?
Yes.
At this time, was his phone located at this time period, if you know?
No, we did not locate a phone
What
initially.
about his credit cards?
I don't recall.
Okay. Did you, at some point in the
Hang on.
afternoon
I
hour,
took the credit cards out of the wallet and put them with the phone in the freezer and left the wallet on the couch. Why would you do that? Why wouldn't you just put the whole fucking wallet in the freezer if you're going to do that? Why would you put it in the freezer for a start? What? Is that to stop any GPS sat nav because it's a metal box? Is that to rectify? You could just take a hammer to the fucking thing. Like, really?
hours, you can go back to your desk, apologize. Did you, at
No,
some
they
point in the
didn't.
afternoon hours, come into contact with another individual who arrived on the scene and appeared to know Rosario Gutierrez?
Yes.
And if you recall, about when was that?
It was about 2:30 p.m.
So you had been there almost 3 hours,
No.
Yes.
and officers had been there for that period as well?
Yeah.
You weren't the first there.
They've got small splinters of wood with blood and hair on the couch, but they didn't find a weapon, and apparently the house is covered in blood up the walls, fans, everywhere. Yeah, so they haven't located a murder weapon. They haven't located a body. I think they were possibly saying a bit of both, maybe, but bit of blunt and sharp. Oh, you said that. Sorry, I read the first bit. But we'll have to wait for the ME, I suppose.
Right.
So when Mr. Campbell arrived, he had not been
I
called to the
thought
scene,
so.
to your
Right.
knowledge?
Scraping my
When he
nails
arrived,
on a
did you speak
blackboard
to him?
at 3 o'clock in the morning?
Myself and Detective Korea did, correct.
And what, if anything, can you say about his demeanor when he arrived at the scene?
He was extremely worried, concerned about the welfare of Rosario.
How did he know to arrive, if you know?
Objection calls for speculation and hearsay.
I think blunt force, but the prison witness says Zachariah.
Let's see, how do I rephrase
Told him, okay. The snitch.
Pursuant to your investigation, did you come to have an idea how Michael Campbell knew to arrive at the scene?
Yes.
And what was that?
I'm going to object. It honestly calls for double hearsay, Judge.
Yeah. Why don't you ask these questions of
That
the
covers all
crime
that.
scene analyst?
Yeah, it's really not for the truth of the matter. It's
Otherwise,
simply
you're just gonna
to
double up.
orient how this
Waste
person arrives
everybody's
there and
time.
sort of what happens next.
Well, if it's not for the truth of the matter, then
It's not relevant.
it's usually not relevant.
Yeah.
Well,
Yeah. He can't. He hadn't tested it, so what's the point?
when you said Mr. Campbell was highly concerned, what else can you say about what your observations were of his physical state when you saw him?
Who the fuck is Mr. Campbell?
He was worried. He said that Rosario was
Apparently, yeah.
Um,
Or was being chased with
why don't you
an
rephrase
arterial
your question?
wound. Don't know.
Well, we're getting into a lot of supposition, and
Could be.
I've caught the scent of some real hearsay.
I got the scent of some real hearsay. Oh my god. What if anything?
Based on the demeanor of Mr. Campbell, what happened next? So you saw him. Did you ask
Yeah.
him some and I'm not asking any answers. Did you ask him
Yeah.
some questions?
I did.
Yeah.
And
And it was everywhere. And so I let the crime scene analysts do their job and they can report on that. Okay.
what was your impression of his level of cooperation or forthcomingness in terms of your experience as a police officer and investigator at having arrived at the scene?
Miscellaneous.
My impression of Mr. Campbell was that he was concerned for a close friend of his, who he hadn't heard of from in multiple days in a row. He was concerned.
Without talking about without talking about the content of
Judge,
what,
I'm going to object and ask that the last comment be struck from the record as far as what he did, what Mr. is non-responsive, and also it calls again for hearsay.
This is the
What Mr. Campbell said.
Sorry.
It certainly, this is why I was concerned about the scent of hearsay. What the testimony that the detective has given is, the appearances of whether someone appears anxious. Those are conclusions we all reach in our everyday lives, and that's okay. That qualifies.
Well.
It was my impression that you felt that the ruling was.
Well. What are we doing now? Why are we standing? Are we leaving? We're having a break? Yes, we are. All right. We resume.
And there's some right around the corner too.
There. Right there.
Oh, yes. Yeah, absolutely.
See, I don't think he's attractive at all.
And I remember when Sister
Mm-mm.
David said that
Too
she had
pretty.
eyes in the back of her head, and I was only 5 years old. And
Sorry, I'm going to ask that the portion of the officer's testimony regarding and we can come up if you need, but a Hasseltine objection on the grounds of what the officer
Hasseltine
stated
objection.
about
it does sound like Hazel.
A Hasseltine objection. All right. Come on, Edahef. What is it? A Hasseltine objection. Anyone? No? Dust. Anyone? Taking offers. Bids from the back row. Hasseltine. Yay, let's look it up. All right. All right. Oh. Got trigger happy. All right. Hasseltine objection. Come on, then. How do you spell the goddamn thing? See, we learn things on this show. Types of objections in court. A guide for lawyers. Objections in criminal trials, hearsay. Standing objections, insufficient to preserve Hasseltine error. All right. That's one. It's got Saltine in it. Let's see what it says. Oh, it's on point. Wisconsin State Public Defender. All right. Under the facts and circumstances. Oh, this is actually a. Okay, so. I have to read the whole sentence because it's under the facts and circumstances of this case, it was incumbent upon defence counsel to police testimony. This area of the law, what a therapist can and cannot testify to, is complicated. As a result, we hold that when an expert witness is permitted to testify in an SA case as to common characteristics of SA victims and to the consistency of those characteristics with the victims in the case of the trial, and when the expert presents extensive testimony on those and related subjects, a standing objection is insufficient to preserve challenges to Hasseltine violations. Well, that didn't tell me what a Hasseltine goddamn objection was. A standing objection insufficient to preserve. Oh, Tam got it, has she? She's quicker than I. Let's look it up. Oop. The lawyer phrases question in a way that inaccurately summarizes what a witness has previously stated, whether intentionally or unintentionally. So it's like what's it called? Oh, my brain is not working. Like, I can't even think of the word I'm trying to think of. No, not happening. It's too late, too early in the morning. That is going to annoy me now because I'll be thinking about it. A prior consistent statement. That's what I was thinking of. So basically, it's yeah. What? Oh, you asked ChatGPT. No, but I'm trying to. Don't worry, I was trying to explain something else.
Resulting evidence.
Judge, it doesn't have to do with truth or vouching for the truth. It has to do with, again, motivating what kind of decision you can make. If one individual is in some way appears to not be providing you full information, you have one sort of course of conduct as an officer, and you have to prioritize. If you have an individual where your impression, for whatever truth it is the opposite of that, and you're getting all the identifying information, obviously you prioritize other investigative avenues at that time.
Arguing no.
I thought you wanted me to. I apologize.
Well, no. Okay. I'm talking about your presenting the argument that's reserved for the later part of the case, not arguing the objection. The problem is, I do think it's Hazeltine evidence.
We're still on the first.
It's almost a dead ringer from the social worker testifying. With Mr. Campbell at that point. I'm not saying it isn't. And
I think I need to go to bed.
It's not permitted to speculate on the accurate. The detective exists in the world. Okay, thank you. Go ahead.
Were you able to obtain identifying information on how to reach Mr. Campbell again in this case?
Yes, we got name, address, phone number. He provided everything.
And was there any difficulty at all in getting him to agree to give you that information?
No.
When Mr. Campbell talked about other people that he was engaged with and talking about, et cetera, what can you say about his level of cooperation in providing collateral numbers or ways to contact those people?
Mr. Campbell provided everything that he knew regarding phone numbers, addresses, all that. He was very forthcoming.
Based on all of the things we've talked about, did you believe it was appropriate to finish your conversation with Mr. Campbell and get back to the rest of the investigation of this case at that time?
Yes, he presented no reason to hold him or to further question at that time. He was free to be left.
And I want to go back to our conversation regarding Sadie Beecham. Okay, now again, that conversation was before you went into the residence, right?
Correct. It was ultimately the first thing I did was talk to her.
Went talk to her, and you mentioned that she was physically shaking and she appeared frightened for her children. Am I correctly summarizing that?
Yeah, she was very scared.
Okay. So one possible investigative avenue would have been to immediately take her down to the station and walk her through some more details. In other words, not just briefly have her tell you what she knew, but be very detailed about it at that first moment. That would have been a possible thing to do. Is that right?
Yes.
Were there concerns expressed by Sadie Beecham that caused you to feel that that should not be how you prioritize?
Yes.
If so, what were they?
Based on everything she had witnessed, everything that she had experienced, she felt as though her children were in danger, and she needed to get to them.
And why did she feel they were in danger in general? What was she saying to you in that initial interview that caused you to say, yeah, that's something I'm going to prioritize. I'm going to allow that to be the priority?
Because she knew, she was aware that Zach Anderson knew where the children were at that moment. So she needed to get to them and bring them somewhere where he wouldn't know where they are.
And when you say Zach Anderson, is that person you now know in this investigation?
Yes, the defendant.
So for the purposes of our record today, when you have referred to a person named Zach Anderson, can you point out who that person is? Say what they're wearing today.
He's sitting in a defendant chair in the middle with the gray suit, tan and blue tie.
Now, as Sadie Beecham was expressing her worries about the safety of her children with Zachariah Anderson, the defendant, knowing their location, was she still manifesting those physical shakings and scared things you've talked about so far?
Yes.
Based on what she told you, the content of what she said, and what you observed about her physically, did you make a decision about whether she would be allowed to take care of that priority before you interviewed her further?
Yeah, she provided where the children were, where she was taking them, and that she would be coming back as soon as that was completed.
And was there anything about her demeanor that caused you concern about her level of cooperation, such that you might feel you had to take other steps, to preserve an ability to be in touch with her?
No, she was genuinely scared.
Consequently, were you able to again interact with Sadie Beecham later that afternoon?
Yes.
And had, to your knowledge, had she been given the time to accomplish the priority she had?
Yeah, I believe she was. She left that scene after talking with her roughly 1 o'clock, 1:30ish, and I met her again at about 3:45.
Okay, now I want to now bring you back to, so everything we've talked about so far has occurred in the afternoon hours, starting at 11 a.m., but now the afternoon hours of May 19th. Is that correct?
Correct.
At some point, did you have occasion to know that the defendant had been placed in custody?
Yes.
And if you know, what jurisdiction or was it Kenosha police officers who placed him in custody, if you know?
No, it was Mequon Police Department.
And did he eventually have occasion to be in your presence?
Yes.
Where were you present with him? Were you in Mequon or in Kenosha?
He was arrested in Mequon, brought to Kenosha.
So your interaction with him was in Kenosha?
Yes.
And if I indicated that appears to have begun any interview of him occurred to have begun at 10:48 p.m. on the 19th, 10:49 p.m. on the 19th of May 2020, do you believe that to be accurate?
Yes.
And am I correct that the interview ended at approximately 12:18 a.m. on what would then be the 20th of May?
That's accurate, yes.
So if I'm doing the calculation, that is 1 hour and 29 minutes. Does that sound right?
Yes.
Okay. And did you Mirandize him? In other words, read him his rights during that interaction?
Yes, he was read as Miranda rights.
And during that interaction, how many people were involved in any questioning of the defendant?
It was myself, Detective Correa, and Mr. Anderson.
And was he in Was he in an open area, or was he in an interview room? What sort of environment was he in?
So we were in an interview room, Detective Cree on one side of the table, Mr. Anderson on the other side of the table, and I was sitting in between.
And at the point that you came in contact with him, had you received guidance as to what the defendant was aware of about any circumstances regarding Rosario Gutierrez? In other words, had you been made aware that he had some knowledge of some subject matter as you began to speak to him?
Yes, it was my understanding Mequon PD had informed him why they took him into custody, and he knew why he was coming to talk with us.
And so do you believe he had an awareness based on the information you were provided that an individual named Rosario Gutierrez had disappeared?
Yes.
So you believe he knew that at 10:49 p.m. on the 19th of May?
I'm going to object as far as speculation as to what he believed Mr. Anderson knew.
Well, Judge,
And if it's not speculation, then there's been a lack of foundation.
again, it goes to what the officer did at what point in time. So,
If I may respond to that, Judge?
Go ahead.
Thank you. This isn't getting to why the officer did something, or this is getting into statements of Mr. Anderson and what Mr. Anderson believed to be or not to be. I think we need to make a clear distinction between the other witnesses.
Well, this is it's similar to the other witnesses, but this is a huge amount of speculation, and it's explanatory only on the issue of why the police acted as they did, which in and of itself is only is usually not an issue that we examine in any depth. There is, however, a claim in this case, which has been made by the defense, that the police did a inadequate investigation. And so to some extent, we're scrutinizing, well, you're scrutinizing the adequacy of the investigation in terms of the ultimate issue for you, which is the pursuit of the truth of this incident. His conclusion from what he heard from the defendant is totally insufficient to establish what the defendant was thinking, and is explanatory only of why he acted as he did in furtherance of the investigation. So I'm going to let the question be answered, but you must understand that under no circumstances are his conclusions legally adequate to base a verdict as to the truth of anything in our strictly for explanation of course of the police investigation. Is that clear? Okay, thank you. Go ahead.
And because of the hour, I'm going to move on to another topic, and at some other time, I'm going to come back to the interview, just because I don't want to chop that up.
Would you wish?
So I'm just explaining to the court why I'm changing topics after the court ruled. Detective, did the Kenosha Police Department do some searching at a residence that they believed was owned and occupied by the defendant on May 19th, 2020?
Yes.
And was that address 6813 West Highland Road in the Mequon area?
Yes.
And on the 19th of May, were you in any way involved in that search?
No, I didn't partake in any searches there that day.
And was that partly because you instead were involved in interviewing the defendant?
Correct.
Okay. On the 20th of May, were you part of a return to that address at 6813 West Highland Road to check out additional areas and to do additional search for evidence?
Yes.
And was that during the daylight hours?
Yes.
And you hope that being there during the daylight hours, I assume, would assist you in searching the property. Is that correct?
Correct.
Okay. Do you recall in general? Can you, in general, describe that property? In other words, how do you get there? How do you get in there? And what, in general, do we have that you needed to look at?
Yes, it was a gravel driveway entering the property. There was a house and several outbuildings, including a couple garages, a couple old like chicken coop areas, a couple lean-to parking areas, some sheds, and I remember there being a camper parked on the property as well.
And when you got there on the 20th, did you observe vehicles that were of some interest to you at that time?
Yes, there was a black Audi sedan and a black Chrysler minivan.
And had those vehicles in some fashion come up in your interview with the defendant on the 19th?
Yes.
I'm going to show you now what's been marked as State's Exhibit 1, Photo 254. Just ask you briefly if you recognize that item from your search of that Mequon area residence on May 20th.
Yes, that's the black Chrysler minivan that I saw at the residence.
And did that vehicle appear to be owned by the defendant, if you know?
I don't recall.
Okay. Then at some point, first of all, did you actually search that vehicle, or did you just observe the interior of that vehicle?
So I looked in the side and rear windows of the van. I never went inside.
And what could you, in general, observe from the inside of that van?
Observed a container of Clorox bleach wipes,
Hello, Mango.
an opened box of garbage bags in the back. I observed that the rear seats were out of the minivan. I also observed that there was a large piece of carpeting removed from the back. About a third of the carpeting in the back area had been roughly cut out. And the carpet that remained had several white blotches on it that appeared to be like a bleach stain.
I'm going to show you now.
That's speculation.
I'm going to show you now what's been marked as Exhibit 1, Photo 263. Is
Is
that a vantage point or a view that you believe you observed in the context of May 20th, 2020?
So that's with the tailgate up, the lift gate up on the back. But yeah, I was peering through the window of the van, and that's what I observed.
This is the vantage point. Essentially, this is from the back, but this is what you saw when you looked inside?
Yes.
So if you could take, if the court would indulge us and let you have that pointer again, then I'd ask you to approach and first point out to me where the items that appear to you to be bleach stained.
I don't need to talk.
Where's the area that you felt appeared to be bleach stains?
This area here, here.
Okay. And then the area that you said was about, I think you said about a third that was rough cut. Is that area depicted in this? And if so, can you just point that out in general?
You're inquiring about the area that was cut out, correct?
Yeah, if you could just point that out for the jury. Where's the area?
This whole third back section.
And does that area include exposed wires?
It does.
Okay. And exposed sort of bottom of the vehicle because the carpet's out?
Correct. This didn't
Really?
appear like a factory,
No.
like how it comes,
It's
because
shit.
the under insulation area here was kind of sticking out, and a factory cut would be nice and clean. This was not clean cut.
Now, did you do anything further with the van, having made these observations yourself?
That day?
Yes.
No.
Okay. Was the van retained as evidence so that other decisions could be made about the van based on the observations at a later date?
Yes, it was secured and decided that we would take the van.
Okay. From that Highland Road address?
Correct.
And where did it go to, if you know? Only if you know.
The Wisconsin State Crime Lab.
Okay. And what is the Wisconsin State Crime Lab a place that analyzes things like this van, if you know?
Yes.
You can sit back in your chair.
Really?
And so would that be the logical place you would send it for a more thorough investigation than the Kenosha Police Department is able
Killer
to
with their name then, weren't they?
Yes. State Crime Labs probably would do the most thorough job of processing evidence.
I'm going to now ask that you take a look at Exhibit 1, Picture 271. Is that a vehicle or a vantage point you recognize from the residence?
Yes, that was the Audi sedan that was parked in the driveway.
Had this also come up in the interview?
Yes.
All right. And so that was also at his residence on the 20th when you arrived?
Yes.
Did you have an opportunity to search the house itself?
Yes, I went through it.
Do you recall how much land we're talking about here?
I believe it's 4 acres.
And did you have an opportunity to search the outbuildings that you described?
Some of them, yes. I personally, some of them.
Did you have a crew of people with you that day?
Yes.
Do you believe that, and was it Kenosha Police Department?
Yes.
Do you believe that all the buildings were searched on the 19th and the 20th?
Yes.
And were the grounds searched as well?
Yes.
Was there anything of note or interest to you, knowing that you've talked about the weather conditions over the last few days before and the heavy rain? Was there anything of note in the outdoor area that was of any interest to you, particularly knowing that it had been raining?
Yeah.
Yes, there was a larger sized fire pit that was smoldering directly behind the residence in a grassy area.
And can we see that general area in this picture or not really?
Just here, I can point.
Yeah, if it's partially depicted.
How many fire pit murders have we actually watched in the last couple of weeks?
Okay. All right, you can go back.
Melody Farris.
And you said that was still smoldering?
Over.
Yes.
And what does that mean to you? How were you able to tell it was smoldering?
It appeared the ash in the fire was still burning and creating a smoke from it.
And was it? It looks fairly sunny at the moment you're there on the 20th. Is that at least based on that picture? Were there moments of sunshine on the 20th, that you know of? It's not the 19th. It's the day after the 20th.
Yes.
Okay. At some point, did you also find that there was a dumpster at the residence?
Yes, it's in that picture right there.
Okay. Is it a blue object in the picture?
Yes.
Were the contents of that emptied and looked through?
Yes, we actually had a dump truck or a loader come and dump the contents out in the driveway.
And was there garbage either in the house or attached to the house in some fashion, connected with the house? Garbage bags, garbage cans?
In the dumpster?
Okay. What about in the home?
Yes.
Okay. Was that garbage searched?
Yes.
And was there a trailer located at this home?
Yes, camper.
And did it have debris?
Yes, there was a trailer. There was also a camper trailer.
Okay. So I'm sorry. Okay. So there was a trailer like that somebody would use as a residence or a place they might park at a campground or something?
Yes.
Okay. Was that searched?
Yes.
Okay. Was there also a trailer that someone pulls to move items around?
Yes, it had. It was a sided trailer with some furniture and like lath and other construction stuff, I guess.
Where was that located at the residence in general?
Next to the dumpster.
Okay. And in that, were the contents of that trailer that we've just talked about also looked at in this case?
Yes, it was thoroughly searched.
Okay. I'm going to show you what's been marked as State's Exhibit 1, picture 274.
I'm going to have to release one.
Is that the trailer we talked about?
Christmas album, yes.
Yes.
Before it was looked at item by item?
Yes.
Actually.
Now I'm going to show you what's been marked.
I wrote, the first song I wrote was actually a Ty Tucker song back in January. So that summarizes his entire case. I'll play that for you later. Yeah, absolutely. Yeah, they're not very good at it, are they? Christmas album. I like your thinking.
As Exhibit 1, page 275. Is that the same trailer?
Yes.
Is that a vantage point of the trailer that is a way shot of some tools that were located in that?
I was going through all this shit, but I didn't think they found any evidence. So, what's the point?
In that trailer?
Yes.
And again, is this before the vehicle itself, or the trailer itself was looked at item by item?
Yes.
And then I'm going to show you what's been marked as the photo number 276 in Exhibit 1. Is that a close-up of tools located on the defendant's property at Highland Road in that trailer?
2 hammers and a knife.
2 hammers and a knife, and the knife is in a sheath of some kind?
Correct.
And are these all true and accurate
I didn't know
pictures? In other words, that's what you remember from the date of?
Yes.
They
So
found
at some
some
point,
cast
did
and,
you come
they-
to believe that
Yeah, but not in the trailer.
persons who you could identify who had last seen the defendant described him as
Not
wearing
really.
a flannel shirt?
I'm going to object as far as hearsay. That is being used for the truth of the matter asserted.
It only goes to, again, these are people who are going to testify. It goes to why he would search for this particular item. You know, he's doing a search. It only explains why this item would be an item he is searching for.
You don't have to go through every item on the
You
property.
recall
though.
a flannel shirt being brought up
Sure.
by witnesses saying when they when they last saw the defendant, he was wearing a flannel shirt of a certain type.
Yes.
And were you provided a picture of that flannel shirt?
Yes, I was.
So you knew precisely what sort of shirt and what you were looking for when you did this search warrant on the 19th and the 20th, weren't you?
Yes.
You weren't there the 19th, but on the 20th you were.
On the day of the 20th, I was, one of the key things I was looking for was that flannel shirt.
Okay, so I'm going to show you what's been marked as State's Exhibit 42.
No, they need to watch Mr. In Between.
40, sorry.
All right.
So is that a picture provided to you by witnesses so you knew what shirt to look for?
Yes, what you see
The
is
next. Oh,
significantly blurrier than the photo that I have. It was a lot clearer, the one I looked at.
But it does depict the same shirt.
Yes.
Okay. And so you looked for
go
that
on
shirt
lunch shortly.
at Highland Road.
Yes.
Did you, was that shirt found in any of the buildings that we've talked about?
Might wind
I was
up.
unable to locate that shirt.
Was it found in any of the garbages that you looked at?
No.
Was it found in any location on that property in any way, shape, or form?
Something's
No.
going on my back. I can feel it. I can feel it in my waters.
Having seen that a third of the van carpeting of a van on the property appeared to have been not industrially cut out, did that become something you were interested in?
Absolutely.
And so as you searched all of the areas we've talked about, did you look for this van carpeting so that you'd be able to account for it and see if it had any evidentiary value?
Yes.
And did you find that in any part of this property or location?
No.
Were you, had you spoken to witnesses who indicated that they had seen brand new duct tape and brand new rope at the residence just on the day that Rosario Gutierrez disappeared? Were you told that on that same day, earlier in the day, duct tape and rope had been present at the residence?
Yes.
That was new.
What's that?
That the person believed was new.
Correct. Brand new in packaging.
And did you attempt to search for those items
I
at
did.
the residence?
I did.
Were those items anywhere located at the residence?
No.
Judge, based on me finishing that topic and the next topic being a fairly significant one, I would suggest.
Oh, you're kidding me.
For lunch.
No problem with that,
That
Judge.
wasn't significant.
Let's take a break and let me ask that you return at 1:15. Is that convenient? Okay, please don't read, watch, or listen to any account of the trial. And any questions? Thank you.
I don't intend to go any further with it, but I believe that is the line, and I'm asking the court if I have permission to go that far and no further.
Go ahead.
Thank you, Judge. Asking why there were other questions that should have been asked that weren't, and then that they weren't able to have the opportunity to question him again is encroaching on the fact that my client asked for a lawyer, and that was why the interrogation concluded. So asking those questions, implying that there's more and that my client chose not to speak, is directly going towards his right to remain silent at that point. So I would argue that the state cannot ask those questions of, oh, would you have asked more questions if you would be able to? Because the inference there is that they weren't able to because he invoked his rights, and that they didn't get to talk to him again because he invoked his right to silence.
And again, I only bring this up because of the issue of the adequacy of the investigation, right? So there are natural limitations. I'm aware I cannot go any further, so counsel indicated, what I can't argue, and I absolutely agree. I can't say here's why or in any way imply that in argument or in question. But I do think it's a proper question right at the line. It's a proper question to ask as I described to the court.
Well, the problem is you're lobbing the ball over into their court. and saying, did you have an opportunity
As
to
you,
ask more questions?
as you often are when you go to the line. You know, right? I mean,
Right,
that's the
but
nature
we don't
of it.
want to do anything brazen.
Right.
You're lobbing the ball onto their side and making them respond. And they're kind of handcuffed. If the answer is, he lawyered up. And of course, then you're in the forbidden woods.
Right.
Um,
So really the analysis though is, am I asking a question that comments on his silence or comments on his invocation, right? So the court is right. It has some consequences, but the question is the question one where I am calling on the officer to indicate in some fashion that he has invoked his right to silence or to an attorney? I would suggest to you, as suggested, the question does not do that. Of course, I can't argue. I apologize.
So yeah, a very tight interpretation. You could make that claim, but the problem, as I say, is you're forcing the defense into a position where it has to come up with an answer, and if the answer is that he had talked to a lawyer and whether he talked to a lawyer or not, he simply decided not to discuss anything further with the police. They can't respond, and so it's sitting out there. And if during the remainder of the testimony, a juror is thinking, after hearing the remainder of the testimony, a juror is thinking, all these years since this, and the defendants never told the police anything more, then you're definitely, what is the name of the case? I think it's Champlain Chambers, one of those. Not one of those, well, whatever it is, the rule is very clear that there's no comment permitted by the prosecution on the failure of the defendant to address the case.
That's a bright line rule, and I'm aware of that.
Okay.
Now, what has happened is the defense has lobbed into the states. You know, I mean, let's be sure we talk about this fully in the venting of what you described. There's been an opening statement. It is certainly said detectives made a number of poor choices here, right? I mean, that is the clear thing, right? So a reasonable juror hearing the 25, perhaps 30 questions that officers did ask would very reasonably, based on the argument made and the ball being lobbed into our court, say, well, why the heck didn't the officers ever address with the defendant why this van is cut out, a third cut out, or any other thing that the state suggests is of significance here? Why wasn't that ever brought up to the defendant? That sounds like it's the same pattern of they didn't test fingerprints at X, Y, and Z. They didn't search this part of the woods. And we're left with no way to respond, because in fact, those questions would have been asked, or certainly could have been asked, had there been a different posture. Now, again, I am absolutely conscious. I am not allowed to bring up an invocation of either silence or the right to an attorney. But I think that the simple declaration by the detectives that they would have asked, that they would have liked to ask additional questions, and that they never had an opportunity, settles the matter. It creates a situation where the prosecution is not going to be penalized based on the argument made by the defense for any question that the juror wishes a detective would have asked the defendant. I mean, otherwise, I'm left without an explanation, right? Because the explanation is a legal and constitutional one. So I'm tied. If the court says I can't even reach that line, I have no way to respond to a juror concerned that in the context of what's been said, what the heck, why wouldn't a detective ask that question? He asked 25 others.
First, about the ball being put back in their court. The ball's in their court. They have the burden. It's never that we've shifted that burden here. And second, as far as the answer to a question of why weren't you able to answer these questions that you would have, the only answer that a detective or any witness can give is that we weren't able to continue questioning because he invoked his Miranda rights. So there's no leeway here. It's not the defense's fault if the state doesn't have any other evidence to support its claims. It's their job. The case that deals with this issue is Griffin versus California, 380 U.S. 609. And in that case, and I'm just going to read, says that a comment to the jury by a prosecutor in a state criminal trial upon a defendant's failure to testify as to the matters which he can reasonably be expected to deny or explain because of facts within his knowledge or by the court that the defendant's silence under those circumstances evidences guilt violates the self-incrimination clause of the Fifth Amendment of the federal Constitution as made applicable to the states by the 14th. There is, and also this concept that I'm going to ask an officer, well, why didn't you ask my client that? Well, obviously, I'm not going to violate my own client's constitutional rights. I would not ask a question of that sort. The questions that the state have outlined are clearly across the line of what's permissible under a constitutional lens and pursuant to Griffin versus California and my client's Fifth Amendment rights.
The case does not stand for the proposition that I can't reach this place that I am. I've been very careful in the litigation here. I've approached the court first. I'm doing the exact opposite of commenting on the defendant's silence. I'm asking the court for guidance on how I can structure a question to a detective that allows there to be no comment on silence, but also allows a fair presentation of this evidence to a jury in the way I've described. Again, the only other option we're left with is a jury wishing there were answers to other questions, knowing a series of questions have been asked, and left with the implication that officers are not competent enough or not or too lazy to ask these additional questions. Now, again, I don't mean to comment on either of the two things. I simply ask the very structured questions. I believe I'm doing it in the appropriate way. It's the exact opposite of the case cited where a prosecutor actually comments on this. I am trying to be careful in my litigation here and ask the court for guidance to be able to ask those two questions. Did you ever get a chance after the interview and so forth? Did you ever question the defendant again? And then the second one is, were there other questions that you would have desired to ask based on your investigation? Period.
Yeah, and of course you did the right thing by bringing it up first.
Sure.
But to the extent that you ask me for guidance as to what you can do, that I can't do. I can't give you advice as to how to
Well, I told you
present your case, and I've made it pretty clear what you can't do.
I told you the two specific questions I intend to ask, so I think the court can probably help me with that.
Well, but definitely the second one is totally out. What was the first one?
The second one is did you have any other opportunities to speak to the defendant?
No, that's
okay.
That's
So the first one was, are there other questions that you desired to ask of the defendant that you did not ask?
Yeah. The fact that you're complaining that you're left without a way to somehow effectively cover this, that sometimes that happens. And sometimes it happens because of the Constitution. But it's what it is. And I don't know if can you cover something like that in your argument to the jury and say,
I imagine that is more problematic.
I didn't tell you what I was going to do to raise your hair for those events. And I think I'm actually going to stop and not do it. But there's at least one way I can think of that I would at least be tempted to do. Well, I'll leave it at that. I don't think you're without a way to buttress the police investigation. But the way that you're explaining to me is not one that I think is one that I would sanction or even permit.
Okay.
No.
Okay, thank you.
Okay.
Do we have any prior record that we have to work out? It doesn't have to be. Were there late jurors or?
No.
Everybody was here on time, but just. Hello. Would you come down, please?
Yep.
John Anthony Ward, what's going on? You have a divorce trial when? When? Well, another state is. Enjoy the day. No, I haven't checked the weather forecast. Are they still talking all kinds of ominous weather this afternoon?
God, we're talking about fucking weather.
Oh, it's tomorrow. Okay.
For Kenosha, they were wavering somewhere between 1 and 5.
I thought there was a chance it was all going to be rain here.
They started approaching, and then they said it's worse south of us, but with the slightest change in wind, Meteorologists are my favorite.
Well, you're being
For
told.
whatever that's worth.
Hey, this is Wisconsin.
About the interview that occurred on May 19th, 2020, regarding the Zachariah Anderson. And again, you've identified Zachariah Anderson as the individual here in this courtroom. Is that correct?
Correct.
And you spoke to him for about an hour and 29 minutes in total.
Yes.
And that was a question and answer format.
Yes.
And did it include the defendant also asking some questions during some of that period?
Yes, he had some.
And did you provide him any nourishment, any food or water?
We gave him water,
Really?
which he requested a couple of times.
And ultimately, that interview then concluded, if I got this correct, at 12:18 a.m. Does that sound right?
Yes.
Okay. So in the time period of that interview, did you provide any threats or promises to the defendant to get him to provide any information?
No.
Did he provide that information? Did he answer some of the questions you asked at least?
Yes.
All right. And did you at some point have occasion to talk about a phone that purportedly appeared to have ended up in a car driven by his ex-girlfriend, Sadie Beecham?
Yes, I did.
And was this something that you asked him about?
Yes.
And what do you recall him telling you about whether he had intentionally placed that phone or some other explanation?
So Zach had said, Mr. Anderson said that Ms. Beecham
Not enough.
had dropped the kids off at his residence. And during the course of taking his son out of the back seat, he believed that this cell phone may have fallen out of his pocket, or his son may have grabbed the phone and put it in the car.
What, if anything, did he say about whether he on purpose hid that phone under the car seat?
No, he said he didn't realize this
That's if
until after Sadie had left and he realized the phone was gone.
Start the lawnmower or
What, if anything, did the defendant say about how he managed to figure out where that phone was then located after it was in Sadie Beecham's car in that location?
Mr. Anderson said he contacted the phone provider, Cricket, and Cricket told him that the phone pinged in North Kenosha.
What, if anything, did the defendant tell you about having loaded an app on his electronics that would, in fact, trace the exact location of that phone prior to losing the phone? What, if anything, did he tell you about that?
He said nothing about it.
What, if anything, did he offer to you regarding indicating that on the date that Sadie discovered that phone, that he actually had accessed that app to be able to discover where the phone was using the app in his own electronics? Did he mention any of that to you?
He said nothing to that.
Did you ask what, if anything, did you ask the defendant about having been to Sadie's home during the early morning hours over the last few weeks?
Yeah.
Did you ask him that question?
Jody gets
Yes, I asked him if he had been to Ms. Beecham's house at any point during the early morning hours.
Let me just stop you for a second. And did they live
Jody's
together
not
at that
ready to
time?
be cranky.
And per your investigation, was he welcome at that house in the early morning hours?
No.
Okay. So when you asked him that question, it was a specific question about in that
Did you
context. Is
check
that
your
true?
Discord
True.
messages?
And what did he first offer up to you as his explanation for for a visit to her home in the early morning hours? What was his first explanation?
He said there was a time when he had picked up a couch late one night and he was dropping the couch off there late.
Go ahead. And did you then repeat the question, ask him again, and ask if he had his kids along on any occasion? Did you ask him that?
Yes, I asked him if there was another time when he had his children that he went there.
And then did he offer that he had?
Yes.
Could he remember the date? As best you remember?
No.
And which children did he claim he had taken along with him?
All three of his children.
Okay. So he has a couple of twins who are younger and then a daughter who's, 10, 11, 12, something like that?
Correct. He said he had taken his daughter as well as the two twin boys.
Was it at night?
Yes.
Did he indicate why he felt the need to take his children? He had the children with him. Is that what you're saying?
Yes.
So why did he indicate he felt he had a need to take his children when Sadie Beecham would have not been caring for the children?
So he first he said there was a car in the driveway, and then he stated he had a premonition that there was someone at her house.
And at that point, were these two in a marriage, as far as you know?
No.
Were they in a situation where any of the children would be at Sadie's home?
No,
Okay, so he and the children drive to her home per his report. Is that right?
correct.
And at what does he indicate happens when he is at that residence?
So he said when he pulls in the driveway, there's a vehicle there with Colorado license plates.
And let me stop you. Does Rosario Gutierrez have Colorado license plates on his vehicle that you saw at his residence when you discovered he was gone?
Yes, he's a white Ford Explorer with Colorado license plates.
Okay, so what else did he say?
He said he got out of the vehicle and looked through a window.
Look through a window through a window at the vehicle?
Looked through a window at the house.
Okay, and whose home is he speaking of?
Sadie Beecham.
Did he say he saw some things inside?
Yes, he said he saw them on the couch.
And did he indicate whether any of the children were also involved in looking in the windows?
Yes, he said his daughter also came out of the car and looked through the window.
And did he indicate that he had that was something he was a part of in some fashion?
He had told me his daughter did this because she wanted to.
And did you at some point ask the defendant whether he recorded any using any devices of his at Sadie's residence when he and his daughter were there looking in windows?
Yes, he denied recording anything, although he did admit to having a cell phone in his possession at the time that he used the lights on because it was dark.
And was it his regular cell phone?
I'm going to object as far as foundation.
Did he? I'll ask again. I'll clarify. Yeah. Did the defendant explain to you that he had more than one phone that he was using on a fairly regular basis?
Yes.
Okay. And did he describe one as his primary phone and another as his secondary phone?
I guess, Judge, I've been lenient, but all these questions have been extremely leading. So I'm going to object to leading and ask, and then it not be leading.
I apologize. I was just doing it in this situation. I was just doing it because it was a foundational question. So, but
It's just been like 5 minutes of foundational questions then.
They are tending towards being suggestive, so if you can rephrase.
what do you recall about whatever he told you about these phones?
He had two phones, one he used primarily for calling.
And what, if anything, did he say about doing any recording using any devices on this particular date?
He did nothing. No recordings.
At some point, did you begin to ask questions regarding a new boyfriend of Sadie's?
I did.
And what, if anything, was the defendant's discussion with you when you first brought up this individual in terms of things like whether he knew his name, a general discussion of what he appeared to know about this new boyfriend?
He said he found out about the new boyfriend through his daughter, as well as a grandmother. Grandmother had shown daughter a Facebook profile of the subject, and that's how he found out who he was. I asked him what his name was, and Mr. Anderson said I believed it was Junior, and that his last name started with a G, and that he was a Mexican.
And what, if anything, did the defendant ever tell you about the fact that in his own phone he had well, let me stop. Okay, so did the defendant ever reveal to you that he actually did know the full name of the individual that Sadie was dating? Did he ever tell you, yeah, I know the guy's name?
No.
Now, at some point, did you begin to focus on the vehicle that the defendant may have driven at various times that you were interested in?
Yes.
And what vehicle specifically were you interested in regards to your interview with him?
I asked him about the Chrysler minivan that was parked in his driveway.
And what do you recall about the defendant's response when you first suggested anything to the effect that he was a driver of the van?
He described the minivan as either being black or blue or something, and that was his words. He also indicated that he doesn't drive it much, and that it's basically there for the taking.
Did he describe to you that he drove a different vehicle, if you know?
Yeah, the Audi. He mentioned the Audi.
Okay. And what, if anything, did he say about whether he had ever been in Kenosha at a time that Sadie had been there?
He said he couldn't remember the last time he was in Kenosha.
Period?
Period.
Okay.
He did mention that he plays board games with his brother, and they may have been in Kenosha, but he didn't recall ever being in the city of Kenosha.
And in connection with being there because Sadie was there, what, if anything, did he tell you about that?
I'm sorry, repeat that?
Yeah, did he indicate that he ever followed Sadie down here to Kenosha?
No.
At some point, did you direct your questioning to whether anything had ever been taken from Rosario Gutierrez's vehicle, that truck?
Yes.
And what, if anything, did the defendant tell you about whether he had taken any items from the vehicle of Rosario Gutierrez?
He told me to spare the accusations. He's already been accused of this and that it didn't happen.
And what, if anything, did the defendant offer to you that in one of his phones, there is a screenshot of, in fact, a registration document regarding that truck?
Nothing.
What, if anything, did the defendant say to you regarding whether he had any jealousy towards the fact that Sadie had a new relationship?
He had admitted to me that he did have some jealousy, however, spun that and said that Sadie was the one that was jealous of him.
And what, if anything, did you ask whether these two individuals, meaning the defendant and Rosario, whether he had ever seen Rosario?
I did. I asked him how many times he had seen the subject he was referring to, and he had told me it was just the one time when he peered into that window.
So what, if anything, did the defendant offer you about about his phone being in Kenosha on May 13th, which would be a different time than the time that you are speaking of? What, if anything, did he offer about that?
Nothing.
What, if anything, did he offer you regarding the idea that he was texting Sadie, directly quoting things that Rosario was telling Sadie in Rosalio's residence on May 13th in Kenosha?
He said nothing.
So as to May 13th in Kenosha, what, if anything, did the defendant say at all about that in the context of perhaps being a second time he had seen Mr. Gutierrez?
It was never mentioned.
At some point, did you bring up an individual named Steve Lentz, or did the defendant bring up a person named Stephen Lentz to you?
Yes.
And just so we understand, who is Stephen Lentz in this investigation, if you can tell us?
Stephen Lentz was identified as a friend of Mr. Anderson, a neighbor. At one point, Mr. Lentz actually lived in his backyard in a tent at one point. Mr. Lentz's mother lives right down the street from Ms. Beecham, about 400 feet down the road on the opposite side of the street.
From where Mr. Lentz, and was Mr. Lentz residing there in April and May of 2020?
Yes, he was.
And from Mr. Lentz's then residence, could you see any portion of the house or a place where Sadie Beecham was living?
Yes, you could see the driveway of Miss Beecham's residence.
And were you able at some point to obtain a phone number from Stephen Lentz?
I did.
And just for purposes of us clarifying, was that phone number based on the records that you reviewed, et cetera, 414-378-4935?
Yes, I believe so.
Okay. So let's go back to the interview with the defendant. At some point, Stephen Lentz came up. What do you recall about how he came up?
We went back to the idea that he had a premonition someone was at the house. Ultimately, Mr. Anderson told me that there was a guy named Stephen Lentz that would call him and tell him when vehicles are in the driveway. But he also stated that he had never told Mr. Lentz to provide this information.
And what, if anything, did the defendant ever tell you about communicating with Stephen Lentz, asking him on occasion if there were cars in Sadie's driveway?
Nothing.
Now, when you spoke to the defendant, what were you telling him that you were questioning him regarding?
I told him we were investigating the stalking incident.
Did you tell him who the people were who you were suggesting he might have been stalking?
Yes.
Okay.
Did they include any stalking charges? Is a lesser included? What the?
Car and suspected that she was going down to Kenosha to visit Jr. because she had a nice jacket in her possession.
So do you together to give you wrong information, correct?
I don't recall him saying that. I know he did say he just didn't remember because his memory is bad.
And what time did this interview happen at?
11:30ish till just after midnight, 11 o'clock to midnight.
So you agree that it's likely that someone could be tired after all day and then being interviewed at around midnight?
Sure. Could be tired. Oh, yeah, sure.
You also, in talking about Mr. Anderson's interview, talked about Stephen Lenz. Remember that?
Yes,
And that's Lenz.
correct.
May I use the Elmo judge?
Yes.
Thank you. And you said that, well, the state asked you that Mr. Lenz would be used as kind of a eyes for Mr. Anderson.
The state said that?
Well, yes. Do you remember being asked that questioning?
I remember the questioning about Mr. Lenz, yes.
And you said that there was communication between them that showed that Mr. Anderson was asking him to look in on Sadie's house,
And I
right?
did have-
Are you saying that I asked that?
No, I didn't say that.
Okay, because that long string of communication and your investigation doesn't exist, correct?
I didn't say that.
Okay. Did you see the communication between Mr. Anderson and Mr. Lenz?
No.
Okay. So you don't know what they actually talked about then?
I know there was text messages. I don't know exactly what those text messages said. I didn't deal with that part of things.
Okay. Do you remember who did?
I don't know.
I want to go back now to follow up on some things that you first started testifying about. Primarily, when you first got to the crime scene, you had noted that it's important to make sure that you're very careful with how you enter into a crime scene, correct?
That's correct.
And why is that?
We don't want to damage evidence. We want to preserve it as best we can.
And in your experience, you'd agree that when you are processing a crime scene or entering a crime scene, it's important to be extremely thorough.
Of course, yes.
Now, you talked about how Officer Van Wee, some other officers came in, and that they were very experienced in evidence processing as evidence techs, correct?
Yes, they are experienced.
You said they were specialists with Kenosha Police Department, right?
They have the title of evidence technicians.
Now, do you have any specialists that deal with missing persons cases?
Nobody with the title.
So you had noted during your direct examination that you were an investigator in this case, correct?
Detective, yes.
And role of a detective in a case with a missing person is to try to figure out what happened to them
Yes,
and where they might be
yes,
and who may have been involved in the disappearance.
yes.
So besides Mr. Anderson, who did you investigate as being involved in the disappearance?
Personally, I didn't investigate into anybody else. We did look. We looked for other leads, other clues, other evidence. But personally, I didn't take the initiative to go look. specifically at somebody else.
I'm gonna pull up an exhibit.
And Judge, I apologize. I'm not going to use the Elmo at this point. The state's kind enough to pull up one of the exhibits since it's already connected. And I'm pulling up what's been previously marked as State's Exhibit 1, Photo 150.
Is the TV on though? Oh, okay. How much you said 150?
150, yeah, thank you.
Looks like it's just kidding.
Thanks, Jessica. Oh, God, yeah. Thank you. So you had previously testified about this photo, and you had talked about how there's a standby screen on the TV, correct?
Yes,
And it was determined that that was a standby screen for Hulu, correct?
I believe so. Yes,
Did you subpoena Hulu to get the usage records?
I didn't. No,
Could that have been something that you could have subpoenaed for?
I don't know. I have never subpoenaed Hulu.
Okay,
Possibly.
all right. And then did you check the make and model of this type of TV?
No,
So you'd agree that there are certain TVs that have standby modes and sleep modes, correct?
I don't know.
If you left, you don't, do you have a TV at home, Officer Detective?
I do.
Your TV, if you turn it on, does it stay on or would it turn off after a certain point of time?
I don't know.
Okay, is it possible that this, you didn't check to see if this TV had a sleep timer or anything where it would have turned off after a certain amount of time?
I did not check personally. No.
And you agree that that could have been useful information in determining a firm timeline?
Potentially.
And then you had also talked about how there appeared to be some items that could have been knocked off, but you weren't sure. Remember that testimony?
Yes.
And you're not sure because prior to May 19th, 2020, you had never been into that residence, correct?
Correct.
So the items on the floor, it's possible they had already been on the floor because you didn't know how this apartment looked previously.
That's correct.
Thank you, State. I no longer need that exhibit up. Thank you. You also talked about when you looked in and you saw some pooling of blood that you noticed a void, right?
Yes.
And I think you said that that void was where a rug would have been at some point.
That's what it appeared like to me. It looked like a rug had been there at one point.
Did you determine the size of that rug?
I personally didn't.
Do you have any information of whether any officers in the investigation did?
Not that I know of.
But you were familiar enough with the layout of and the size of the apartment, right?
Correct.
It was a relatively small apartment.
I would say that, yes. One bedroom.
Okay. It wasn't, in your opinion, it couldn't have been like an 8x12 rug.
No, it wasn't that big.
It was more like a 5'7" area.
From what I recall, that seems to be about accurate.
Okay.
Maybe a little smaller.
A little smaller than 5'7".
Yeah.
Okay. And you said that you looked in the bathroom. There was nothing of concern there.
Not that I saw.
You went to the bedroom. You said that there was nothing of concern there.
Not that I saw.
Judge, I would like the Elmo now. I appreciate it. Thank you. Okay. Pulling up what's been previously marked as Defendant's Exhibit 60. From you being there, what room is this?
Appears to be the bedroom.
Okay.
Like the northwest corner of the bedroom.
And the window, do you see the window in the picture?
Can you change the light maybe? It's hard to. we
Is
could
that
turn
better?
the light off, Judge? So,
As you wish.
okay. You need the light off, or are you good?
I'm good. Can you see it?
Yeah, that's fine. Yeah.
Yeah, we're good. There's a window in the picture, obviously, right?
Yes.
That window, is it open or closed?
It looks like it's cracked
The
open.
blinds or the window?
The window itself.
Looks like it's, one of the panes is cracked open.
Okay. And did you look into that at all? The fact that there was an open window in the apartment?
I didn't look, I guess, what do you mean look into it?
So that window, I'll go back a little bit. That window is accessible from immediately right outside that apartment building, correct?
Yes, it looks outside to the north.
So an individual, if they wanted to gain access into Mr. Gutierrez's home, that could be a point of entry into that apartment, correct?
Correct.
We just saw that the window was open, correct?
So I don't know how many panes of glass are on that window or nothing like that. But it does appear as though the window is slightly opened.
Okay.
Yeah.
And that could have been a point of entry.
Could have been.
So you'd agree that that is something relevant in the bedroom,
Okay.
is
Yes.
it?
Sure. Yes.
And it's important when you don't really know what happened to an investigating to determine every possible outcome or situation of how an individual might have gotten into Mr. Gutierrez's apartment, correct?
Correct.
And you'd agree that that's one of them.
Correct.
You talked a little bit about your contact with an individual named Michael Campbell.
Yes.
Do you remember what he looked like?
I don't.
So you can't remember if he had any facial hair, what his hair looked like?
I believe he had a slight beard. But like I said, it was 2 years ago. I haven't talked to him since. I don't remember.
Okay. And the state had gone into what he was telling you, but he didn't tell you that he was at Mr. Gutierrez's apartment on May 17th, 2020, correct?
I didn't hear that. Yeah, I didn't hear him say that.
And when you were with Miss Beecham, questioning and talking to her, at any point did you observe her on her cell phone?
I may have. It's possible she used her cell phone.
Was she talking to anyone?
I don't recall.
Okay. Moving to your observations on Mr. Anderson's property, and you said you looked into the van, correct?
Correct.
I'm going to ask you some follow-up questions on that a little bit later.
Okay.
You looked in the dumpster. There was nothing of evidentiary value found there, correct?
Correct.
And you had noted something interesting, that you located lath in the dumpster.
Yes.
And in your investigation, you were aware that Mr. Anderson was doing lath removal at a house in Belgium, Wisconsin, correct?
Yes.
And you said there were other areas on the property, and just in a whole, you did not find a body on the property, correct?
Correct.
No human remains on the property, correct?
Correct.
You talked about the flannel shirt, and if the state would be so kind to pull up that exhibit 40. Oh no, I think I got it, Jessica. Thank you. I'm gonna, for record purposes, pull up state exhibit 42. When was this picture taken?
I don't know.
This picture, wasn't taken on May 17th, correct?
Correct. I believe I was older than that.
It was much older, right? And you don't have a single photo of Mr. Anderson wearing that shirt on May 17th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 18th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 20th, 2020, correct?
I do not.
And you said the state had asked you about whether you searched the house and if you found the shirt. You said you had not, right?
We did not find the shirt.
Did you search Christine Remsburg, Mr. Anderson's girlfriend's house, to find that shirt?
I did not.
Did you search Miss Beecham's house to see if that shirt was there?
We did not.
So the only place you looked for that shirt was at Mr. Anderson's home.
The house in Belgium, a tree farm we looked. Yeah, those three places.
Okay. But you didn't, there were places that you could have searched for it and did not, correct?
Essentially,
Okay. So I'm happy you brought up the house in Belgium. Were you involved in searching that residence?
me along with several others, yes.
And are you aware that the state believes that Mr. Anderson, I guess, chopped up Mr. Gutierrez's body at that residence?
Objection calls for conclusion. I don't think there's an evidence in this case.
I can rephrase and ask a better foundation question.
But
You have no idea where Mr. Gutierrez's body is, correct?
Correct.
And you have no idea how his body or where his body is now.
Correct.
And in fact, he's still technically considered a missing person, correct?
Objection. How would that determination by some mystery person be relevant in this case?
that does,
It's fine. I'll withdraw the question and continue on, Judge. In your investigation, you were unable to determine what, if anything, Mr. Anderson had allegedly done with the body, correct?
Correct.
So when you went to the house in Belgium, you found absolutely nothing of evidentiary value, correct?
Objection. That would call for conclusion by the detective.
Sure, I'll go into it differently, Judge. You found no human remains at the house in Belgium, Wisconsin, correct?
That's correct.
And you know that this, in your investigation, you're aware that Mr. Anderson had been there the morning of May 18th, 2020, correct?
I know that at some point he was determined to be there. As far as the exact date and time, I don't know.
Okay. And you found no blood evidence or suspected blood evidence, correct?
At that house?
Yeah.
No.
Did you find any trash bags filled with body parts?
No.
Okay. Did you find any bloody knives?
No.
All right. Did you notice that the property was under construction?
Yes.
And did you see that there, I don't know your expertise in the line of contracting work, but you had testified you had seen lath at Mr. Anderson's home. Did you see things consistent with lath removal at that property in Belgium, Wisconsin?
It's likely that's where the lath came from.
Okay. You noted, I want to move back to Mr. Anderson's property. You said that you had looked into the black van, correct?
I did.
And you noticed that the van carpeting had been cut out,
Yes, is missing.
missing. But you cannot definitively say your investigation didn't produce any definitive answers as to when exactly that carpet was cut out of that van, correct?
Well, objection. His investigation does have witnesses that put a time on that.
Well, then he can answer the question. I think it's a totally plausible question.
why would he be charged with that knowledge?
I'm asking him if he knows.
Well, he can answer if he knows.
Correct.
Yes, I know. I know. We have it narrowed down to when it was removed.
And that was solely based on statements of another witness, correct?
Correct.
It's not based on photos of Mr. Anderson removing the carpet, correct?
Correct.
And there were no other witnesses that could corroborate that one witness's statement, correct?
Correct.
You talked about some duct tape and rope. That was also from a single witness, correct?
Correct.
You were not provided any photos of that duct tape and rope, correct?
That's correct.
And you had never observed that duct tape and rope prior at Mr. Anderson's home.
No, I didn't.
The state, kind of going back to the cross-examination or the direct examination on Mr. Anderson's interview with you, had talked about asked about Mr. Anderson not really admitting to which car he drove, but he said he drove the Audi and the van, correct?
City primarily drives the Audi. He doesn't really use the van.
Did he say he used the van for work purposes?
Yes.
And your understanding is Mr. Anderson's work is as a contractor?
Well, can I approach?
If there's an objection, they can state it.
I think the question opens the door to this officer. He has some knowledge that question. I guess I have no objection. The question was asked, what is his current job, or what's his source of income? That is
exactly, but
that question's been asked. Let's let it be answered. I don't object.
all right, everybody's on board, so.
You go ahead and answer.
Well, if we can have one moment. I'm going to re-ask the question. At,
There was no objection. Shouldn't Candy answer the question?
do you remember the wording of the exact question, officer?
Yeah, what he did for work?
Or were you aware that Mr. Anderson was doing contract work at that time?
Yes.
And there was evidence that Mr. Anderson admitted to that proves that he was driving the Audi around this time, primarily that he was driving the Audi on April 24th, 2022, correct?
I don't know if he specifically told me that. He did say he was operating a car that night.
And that was confirmed by other witnesses.
Correct.
Oh dear. My daughter sent me a picture of a makeup case that she wanted me to order her for Christmas, which I've just done. And the site has brought up, like, you know, recommended things. You might like this type of thing. It's recommending that I buy 10 reusable, seamless silicone nipple covers. Yep, shit you not. You can get 10 of them for $1.42. Yep, reusable, self-adhesive, invisible breast patches for women. Holy crap. There you go. I shit you not. Yep. Breast patches. I think I'd need about 8 of them for Lefty. Holy crap. Oh, they even give you directions on how to put them on. Oh, you can get circles and flower shapes. Yep. If I had to wear those because I wasn't wearing a bra, I'd need to attach them to my knees. Just saying. Come on.
I don't recall.
Okay, but you'd agree those are trash bags in this photo, right?
That's what they appear to be that, yes.
Right.
Okay, great.
I'm going to the next break and I'm calling it a day.
Then you said when you were at Mr. Anderson's home, you had looked into the van,
I
correct?
need to
Did
sleep.
you look at the front window too?
I believe I made my way all the way around the van.
Okay, so I'm going to show you what's been marked as Defense Exhibit 62.
Pay this
This is
bill.
an accurate depiction of the front seat of Mr. Anderson's van.
Appears as such.
Okay, and there were tools in his
Now I've
van,
just got to
correct?
buy for the
I believe
good of
so.
it.
You'd agree that those are tools or a toolbox of some sort
I
on
have
the
no
front
idea what to
passenger
buy
seat.
for.
Yeah, tape measure, tools, looks like a tool bag.
And you'd agree that there's a lot of cluttery stuff around there too, right?
Yes.
I'm going to show you what's been marked as Defense Exhibit 65. This is another view from the behind of the vehicle, correct?
Correct.
And you'd agree with me that there's a lot of dirt and stuff on the floor, correct?
Looks dirty.
Looks dirty. It hadn't been vacuumed or meticulously cleaned, correct?
Doesn't appear as though.
Okay. I'm going to show you another picture of the front, Defense Exhibit number 66. Again, lots of items, correct?
Yes, very busy.
And this is how it appeared to you on, was it the 20th of May?
Yes.
Okay. And another angle of the front seat taken from the passenger, Defense Exhibit number 67. Again, lots of items, correct?
Yes.
And this is how it appeared to you.
From what I recall.
Okay, great. Showing you more pictures of clutter here.
Yeah.
Defense Exhibit 68. This is the front of the vehicle, correct?
Yeah, between the two front seats, looks like.
And we still see a lot of that clutter?
Yes.
And that's how it appeared to you?
What I recall.
Show you another picture from inside the van. Defense Exhibit 69. I think we can see, you can see that dirt and trash a lot more clearly, correct?
Yes.
Does this look like a car that has been cleaned to you?
Doesn't appear so.
You said you also went to the tree farm to help with the search that was executed there.
Yep.
And you're aware that there was a burn pit at the tree farm,
Yes.
and multiple agencies had come to process that burn pit, right?
Yeah, there was approximately 100 people that took part.
And you were able to confirm that there was a controlled burn there on May 8th, 2020, correct?
I believe that was the date. Yep.
And that the owners of the tree farm had alerted the Ozaukee County Fire Department of that burn.
I believe so, yes.
So I'm just going to show you some pictures. This is Defense Exhibit number 70. This is part of that linear search of that burn pit, correct?
Yeah, so I didn't take part in most of that
Okay.
search. I was doing other things.
Okay, but
That looks like the burn pit, and that looks like what they were doing.
sure.
Searching.
So maybe I'll.
I know it's pretty much tattooed. I have tattooed eyeliner and shading on my lids, and I get false lashes done every 3 weeks, and that's it. That's it. And we're up to day 3 already. This is day 3, so we'll be finishing off day 3 and getting on to day 4 on Monday. Yes, I know. I'm normally this time of year, I am in Thailand and getting my makeover done over there. But yes, not to be this year. Not to be. Yes, I look at those and go, and this is probably the nurse in me. I go for practicality. How the hell do you put a tampon in with that? Not that I haven't had to do that for 15 years, but like, no, you just tear yourself a new one. Just saying.
I'll just ask you then. You were aware that was a large operation,
Very large, yes.
and they didn't find any human remains there, correct?
Not that I know of.
I
They
wouldn't
didn't
go that
find
far.
any bloody evidence there, correct?
You can only
Not
you
that I
can
know of.
only see the bits that I let you see.
Back to
part.
Mr. Gutierrez's home.
No, we're
I'm
going
going to
to
show you what's been
continue with
marked as
this one
Defense
because we're
Exhibit
following up.
58.
I've organised another content creator who is really knowledgeable with this case, because this is the case that we're doing the podcast on next Saturday on the 7th. So yeah, I've got Nick Starrow coming, and he knows Zachariah Anderson's brother, Solomon. So I'm waiting to hear back to see whether he can join us as well. So that'd be a nice give us a different perspective from family to see what's going on or how he perceives it. So yeah, that'll be an interesting one. So yeah, I'm following this trial this week because I hadn't even heard of it, and seeing as we're analysing it on the podcast, I figured best we cover it. But I might have a look at it and do it like a sleep stream. So basically, I'll do my live, and then I can pick another trial once the live is finished, and just run it while I'm asleep, because normally a trial day goes for 8 hours, and then I get up in the morning and turn it off, so it's run clean without any commentary or anything. So I might do that if it looks interesting. Let me know, and I'll stream it. Is it on? Do you know where it's? I'll have a look. It's all right.
The number of his apartment building, 3709, that you can see that in this exhibit, correct?
Yes.
And that 3709, you can see that from in the parking spaces right in front, correct?
Yes.
And you had been at this scene during the day and at night, right?
No, they're during the day.
Not at night? Okay. As part of your investigation, you talked to an individual named Kim Labora.
Did? Kim Labora?
She also goes by Undendum Labora. I can go get your reports if that would help.
Yeah, you need to
Okay.
clarify that one.
Yep.
We talked to a ton of people. So.
Yeah, counsel, I'll stipulate to the record if you just want to do that, you're not going to ask what you asked or anything.
Correct.
So I'll stipulate rather than, if you want to refresh, you can, but if you just want to.
I do want to refresh.
Okay,
Thank you.
yeah.
You can hold those ones in the red file till tomorrow.
Guys,
Kim. Oh, done. Okay.
Counsel, for purposes of the record, you don't have to read it out loud, you're just
no,
refreshing it.
for purposes of the record, I've handed the detective a copy of his own report to refresh his recollection. Does that help?
Yes.
Phone records were obtained in this case from Mr. Gutierrez, correct?
Yes.
And I'm going to show you what's been marked as Defense Exhibit 75. Probably going to have to zoom in here and focus, so bear with me.
I'll go in the hour.
This is going to, go ahead, Judge.
Well, if it's going to be brief.
With this point, yes. Then I have some other stuff.
Well, I know that. I wasn't going to end your entire examination. It's 1 minute, 3 minutes.
This will be like 1-2 questions max.
All right, I'll do
Okay, I won't disappoint.
that.
So this phone record shows that these are Mr. Gutierrez's phone records show that he called Kim Facebook on 5/17/2020
Well, it won't start
at
till
8:49
Monday
PM,
afternoon or
correct?
Tuesday then. I'm
Tuesday,
tipping,
yes.
but
And that when we look further up, there's a duration column, and the duration of that
Is that
phone
me?
call was 17
no, she
minutes,
has to
4
smoke
seconds,
through from
correct?
under the.
Appears as though, yeah.
I reckon she
I
might
lied, I got
too.
3 questions, Judge.
I reckon she might.
So if there was a phone call that started at 8:49 that lasted
And I really,
17
really need a wee
minutes,
now.
that's going to
Back
put
in
that
the
phone call to approximately 9:06 PM. I'm terrible at math.
Yes.
Thank you. Judge, we wanted to take a break.
Well, I won't wait for others. But let's take a break, and please don't read about your list of any account of the trial. Discuss the case with anyone, and let's aim for about a 15-minute break. Any questions? Okay, thank you.
Of course it had to stop. Oh, damn bladder. It's one of those.
You also indicated that on
He-
May
he's
26,
doing-
2020,
gotta go.
you continued to review video surveillance, correct?
Of what?
He's had to-
What are we, what surveillance are we talking?
Yeah, I was hoping you could answer that. Can I show you your report?
Sure.
Okay.
What is that?
Sure. So yeah, so we had
My cat's
hours and
all-
hours and hours of video from multiple locations we took. I didn't document what I looked at there, but
Witness
we
all day.
reviewed
All day.
several locations.
The first responder.
I don't know specifically what I was talking about when I mentioned that in my report.
But is it a fair guess that those were locations of interest due to potential traffic patterns of Mr. Anderson?
Potential routes, yes.
And in your report, you noted that you observed nothing of evidentiary value, right?
Correct.
And can you explain to the jury what nothing of evidentiary value means?
I saw nothing regarding a black van, a black Audi, or anything related to Mr. Anderson.
I have no further questions subject to redirect.
I'm going to start from the back. So you were just asked about some video that it sounded like it was a gas station location that you looked at.
Yes,
And that appeared to be on May 25th, 2020, correct?
correct.
You wrote a report that memorialized those fascinating hours, I assume, right?
Yes.
His voice, I think, was
Counsel read to
fading.
you, I reviewed several hours of the video and did not see the black minivan. Do you recall that just being read to you?
Yes.
Is the next sentence in your report.
No, did you lose
However, the
your-
video was from a great distance, making
Oh.
it difficult to make out traffic,
family,
especially
aren't we?
during the hours of darkness. Is that what you say
Don't
next
wanna-
in your report?
I don't know what I'd do
That's what I
without my-
testified to as well.
And so when
yeah, I do.
counsel read to you the first sentence, you had already also tried to testify as to the second sentence, and it's also in your report. Is that right?
If you just read it, it's in the report.
You have no reason to dispute it. Would you like to take a look?
Sure.
I'm going to object. This witness has already testified to that contents, and the video was poor quality and it was dark.
Well, sorry, it's the next
Yeah.
sentence.
What page? Wait,
Yeah.
actually, Mike, what page is that?
It is. So I'm just going to ask you to take a look at your report and ask you, do you agree that after the first sentence that was read, there's a second sentence and it's what you testified?
Yes.
Okay, so it's also in your report, is that right?
Yes.
I've had all of my animals cremated,
You were shown on the doc cam just a minute ago.
and I said to my girls that when I go, that they are to cremate me and mix me with all of their ashes, and then and then create a like they can somehow manufacture it now under pressure or whatever. I don't know how they do it, but they can make diamonds out of it because it's basically carbon. So I said, you can make two diamonds out of us and wear them around your neck. I want to be a diamond. Yeah.
So, or, I'm sorry, before the break, the signage indicating what the 3709 address for apartment 1B. You recall that?
Yes.
And that picture was one where you said that the sign was visible, correct? Like would be visible from the road.
I had a 14-year-old tortoiseshell that I lost last year. Yeah. Slept on my pillow every day. It's not nice, is it?
Yes.
You recall
From
testifying?
15th Street,
Yes. Yep.
from the road.
I've got 2 girls,
That's it?
so they can have a diamond each.
So I'm going to show
But
that to you on
yes,
the doc.
I have
Does that
every
appear
animal
as you
in-
can see to be- Of course, I
Over
forgot to
here,
say
they
that.
it's a very big thing cremating animals, and they have special like hollow statues that are unbreakable, and you can pick all different types of statues that are filled with the ashes, and you can also buy I think it's on Temu or something like that. You can actually buy like ashes keepsake necklaces, like a little like a little gold hollow cylinder that screws onto your necklace, and you can fill it with a bit of the ashes and have it engraved and wear it around your neck. Yeah, lots and lots of stuff you can do. Yeah, if you look on Temu and put in animal keepsakes or something like that, you'll find them.
Does it appear to be a daytime photo, if you can tell?
Awful. It's awful.
It is.
Okay. At nighttime, would you expect there to be substantially different visibility?
I'm going to object. I asked this witness if he had been there at night, and he had said he had not. So it'd be purely speculative.
I think he could.
Go ahead.
At night, would you expect that signage to be significantly more difficult to read?
I would believe that to be a safe assumption.
Okay.
It's dark.
And
Difficult
on
to
the 17th
read the
of May,
sign.
you believe it to be heavy. Was it heavily raining?
What
Yes.
the
Was
fuck
Was it
does
heavily
it
raining
matter
at night?
Yes.
if you could read the
Have
number
you,
or not? Is it the
and
right
so
house or
if
not?
I add in heavily raining at night, would you expect the signage 3709 to be different and more difficult to read than it is in
Who the
the
fuck
current
cares?
state of the daytime photograph?
Rain can obstruct. Rain would obstruct.
Really?
The sign at night.
You were shown a picture. It is Defense Exhibit 65,
Did you go into the wrong house?
where you were asked if
No.
whether the van, and this is the defendant's van, as best you know, correct?
Correct.
You were asked if it appeared to have been meticulously cleaned.
Yes, I've
Recall that?
been making shadow
Yes, that's what I was
boxes.
asking.
Okay. Now, this is not the same view you saw. You saw the van.
I kept whiskers and some of her fur, and I've even got all of her tags and, you know, certificates and bloody immunisation. You know, they've all been being framed in like shadow boxes. I will get to finish it one day.
During the day, for instance, correct?
Through a window, yes.
When you saw it, did it appear to have been selectively cleaned as opposed to comprehensively cleaned?
Yes.
Okay. And what left you to the conclusion
Put it
that
in a
instead of
frame,
someone
Cindy.
comprehensively cleaning the van, have you ever cleaned one of your cars?
Yes.
Do you normally, detective, clean only small portions of your car? So if you have a minivan, you only clean the back third?
Typically not. No.
Would you use bleach on just certain locations, or do you typically clean the entire automobile if you are engaged in your normal activity?
I'd clean the whole automobile and I wouldn't use bleach on carpet.
Okay, so when you observed what appeared to be bleach stains and the back cut out, was it your sort of at least beginning conclusion that somebody had made some efforts to do something to that minivan that wasn't involved in just trying to keep it clean?
Yes, it definitely wasn't normal.
I'm going to show you what's been marked as State's Exhibit 59. Do you recall this pizza box from your walkthrough of the scene?
I know there was a pizza box, but like my walkthrough was what it is, a walkthrough. I didn't stop and do crazy examinations. I didn't evaluate evidence. While I walked through the residence to get a gist of what happened.
So I guess I'm going to ask you plainly, are you the best person from the Kenosha Police Department to testify as to each of these areas or items and whether anyone collectively on this investigation did anything further? Are you the ideal person to ask those questions to?
No.
For instance, if a officer called
But you've had him on the
police
fucking stand all
and
day then.
made some
Really?
determination that this was not an issue in this case, in other words, in terms of the timing, would you know that one way or another?
I know some things. I don't know others.
Oh my
I didn't lead
God.
the investigation. I assisted.
As to the specific fact I asked you,
Yeah.
if an officer made that call and determined it was not an investigative lead, do you know that or would you know that?
Not necessarily.
Okay, and in this case, do you know that?
No.
You were showed a picture that is State's Exhibit, I'm sorry, Defense Exhibit, apologize, 76. Do you recall
This
this?
is me.
Yes.
You recall that it was, I believe it was honed in
Right.
and there's some garbage bags along
Thank you.
the side of that particular
I'm
building.
missing the
you see
point
that?
altogether.
And you were asked whether that was something you personally had reviewed, I believe, correct?
Something to that extent.
Are you aware that in the context of this investigation that those garbage bags were the remains of marijuana grow, that they are potting soil and other remains from a marijuana grow?
I'm going to object on the grounds that one, speculation, lack of foundation, as he already testified, he did not look at those bags, look in those. It's also an argumentative question.
Well, counsel brought it up. I didn't open this door. He's either aware that that's what the contents of the bag are or not. That would lead a reasonable jury to decide, is this an investigative lead about a missing body? If it's bags of potting soil for marijuana, then it would be reasonable to conclude that's not a place, that's not necessary in terms of this investigation.
Well,
And I didn't bring the bags up, they did.
you're asking him about what his awareness was?
Yeah, which is what they asked.
Well, but the investigation is an entire group of separate, proper court.
Which is my redirect question, but this is a question of whether they don't have any investigative lead quality here. And again,
That's
they,
argumentative.
Ask
Oh,
the
they
lead
brought it up.
investigator then, dipshit.
videotaping of the defendant cutting the carpet out of the van. Do you recall being asked that question? Whether there was any videotape available of him, of the defendant cutting the carpet from his van during this period of time? Or pictures, either
No
video or
photos.
pictures?
Yeah, there was no photos.
Okay. Would you expect someone who is trying to remove blood evidence from their van to videotape themselves or take pictures of themselves during that process? Is that something you would expect?
I'm going to object. This question is tending towards argumentative.
Okay.
And pointless.
Yeah.
And ridiculous. And we're prone to making funny faces.
You were asked whether on cross-examination, whether Anderson's home had any body parts at its location or any other blood evidence. Am I correct that the search warrants at Anderson's home were 2 days and 3 days after the time you believe that Mr. Gutierrez was murdered?
Yes.
Okay. And
We do.
do you have
That's
any
normal.
specific reason to believe that at any point that Mr. Anderson either stored the body at his home or did any of the blood work at his own home? Do you have any reason to believe that?
No, we
Okay.
found nothing to suggest that.
And so, again, would a person having 48 hours to no longer be in possession of the body of Rosario Gutierrez or of any of the blood evidence, would a person have enough time during that period of time to either not have that evidence at their home and also to dispose of that evidence?
Of course. Yeah.
Is that a sufficient amount of time?
I'm going to object. This is
Oh my
beyond the scope
God.
of my cross-examination. And it's also argumentative.
Oh, fuck, really?
I
Could someone
I-
dispose of
as
a
to the
body
first
in 48
objection,
hours?
I
Hmm.
think I commented the other day.
Really?
I am always hesitant to limit an examination as not within the scope unless it's really things that ought to have been fully covered earlier. So I'm going to overrule you on that. On the fact that it's argumentative and speculative. Speculative.
I thought the argumentative objection is me being argumentative with a witness. I'm not aware of argumentative being, there being another form of argumentative. I thought it
There are
meant to be.
two forms.
Okay.
One is arguing with the witness, which is really is a branch of things that ought to be taken up in argument. And the lawyer is simply
I don't know how you do that.
witness testify in a way which is a substitute for the argument. That's really the principal problem with argumentative questions, but it can be.
You don't have to
both, but,
define it, Judge.
No, we won't. No, not in this.
Tell it
case.
how it is,
But
right?
that would be speculation as to how long it would take to dismember
Really?
or so true.
You
Okay.
think?
Well, but dismember.
Asked whether you saw a picture of the defendant in a flannel shirt. Do you recall that?
Yes.
And when that picture, and you don't know when the date of that photo was.
I don't.
Your reason for focusing on that flannel shirt is you have multiple witnesses who told you that just hours before Rosario Gutierrez is murdered, in your belief, that he's wearing that shirt. Is that correct?
I'm going to object again on argument and grounds and foundation. There's been no testimony as to what time it's believed that Mr. Gutierrez was murdered or went missing.
Well,
I'll wait for another.
the problem I'm stumbling on with the question is what the detective's belief is. As I say,
I don't know
this
how to
gets
go.
into the argumentative, the subject we were just talking about this is really part of your argument later in the case. that is attempting to be extracted from the witness. And the witness, in order to respond, it seems to me has to employ a lot of speculation.
Well, he has a working theory as to when this occurred. And he is, remember that the flannel shirt is a focus of the search.
Right.
Okay. So the cross-examination question was, well, you're basing this just on 2 witnesses. You have no photo at the time. So it is redirect to say, well, you have 2 witnesses and they are close in time because we have no photograph of him that day. They are close in time to your working theory of when Rosario Gutierrez is killed. So that counters with his testimony that his basis of focusing on the flannel shirt is that multiple witnesses say just hours before Rosario Gutierrez is murdered, per his working theory, based on electronic evidence, etc., that they see him wearing this flannel shirt. So it's not remote in time, which is the suggestion of the cross. And so the redirect is to show that, not that it's true, right, but that he's been provided information that it is recent in time.
If I may respond.
Right.
Thank you. First, if the state wants to ask, do you have a theory about when Mr. Gutierrez went missing, then that's the proper question to ask to lay the foundation for the series of questions, not to ask a speculative, argumentative question without laying that foundation. I have not heard any testimony from detective about his theory of when Mr. Gutierrez went missing or was killed. So again, I maintain the objection.
Counsel and Cross did not ask any foundational questions in that regard either. Why would he have to explain the theory if he's simply indicating it's near in time?
Well, given the opening statement that was made by the defense,
Yep.
I think that
That poor witness.
existence of a quote working theory unquote may be a line that you might want to pursue and could, but that's not entirely clear thus far. And number 2, the way it's being presented is, in my opinion, argumentative, and also it's speculative. The objection is sustained.
When were you told that the 2 witnesses who are your source that the flannel shirt was being worn, what was your understanding of the time that they indicated they last saw the defendant in the flannel shirt?
I believe it was around 4 o'clock Sunday.
Sunday is May 17th?
Yes.
And are you a person who has knowledge of the electronic evidence of this case, at least in the general sense?
I know some.
Okay. And on the same day, is Mr. Gutierrez believed, based on the electronic evidence and his absence of any more responses after, is he believed to have been killed at a time in the area of 10 p.m.?
I'm going to object. This is already extremely leading.
What do you say?
Between 9 and 10 p.m. on the same.
Wait a minute.
I apologize. I thought you said yes. I apologize.
Oh, I'm sorry. I said it seemed it was leading.
Okay, I'm on redirect.
Right.
Okay, so I'm trying to direct him to the place that the court asked me to. The only other avenue I would have to ask this question is to ask him to explain what time, when he is not the detective who formulates that.
The objection to a leading question is based upon the fact that it is suggestive of the answer, and the form of your question was suggestive of the answer.
What time period, in your knowledge, detective, is the time period where it appears that Rosario Gutierrez has been murdered?
Between 9 and 10 on Sunday the 17th.
That's the same day as as you've indicated, around just before 5, that the 2 witnesses saw him in a flannel shirt that seems to match the picture.
That flannel shirt, yes.
You were asked whether Michael Campbell had offered you information that on May 17th that his phone was at the home of Rosario Gutierrez at some point. Do you remember being asked that question?
Yes.
And you knew that Michael Campbell was a friend of Rosario Gutierrez.
Yes.
Did it cause you any concern that that his friend did not tell you that he had some contact with his residence on some period on May 17th?
No.
And are you aware, pursuant to this investigation, that contact that they're speaking about is actually at 1:45 a.m. when you have just indicated that your thoughts on this case is that it would be 20 hours later, 9 or 10 p.m., that Mr. Gutierrez is murdered? So it would be 20 hours earlier. Are you aware of that?
No.
You were shown a picture of the bedroom of Rosario Gutierrez. Do you recall that picture?
Yes.
And that picture had a window in the far side of it, correct?
Yes.
Are you also aware that the reports in this case is that the slider that would face the street was also found open in this case?
Yeah. I don't know.
Oh, you don't know? Okay.
I'm sorry. The sliding
Sliding door.
door
Yeah.
in the living room.
Yeah.
I thought we were talking about the bedroom window.
I apologize. I meant the sliding door in the living room. Are you aware that that was found open?
That's what I was told. Yes.
The screen was closed?
Yes.
Okay. So that would be another logical method of entry, correct?
Yes.
Simpler method of entry than climbing in a window, correct?
Yeah.
The blinds were in no way disturbed that you saw in the picture, were they?
Not that I saw.
And did that picture include notes on it? I'll show you.
I believe on the pillow on the bed.
Judge, if I can have a sidebar on this issue of line of questioning.
You probably are not, haven't had an opportunity to see all of my brewers' pictures in the bag. So why don't we take 5 minutes, we'll be able to do that. Opening day is coming. So please don't talk about the case during this very short break.
All right. Come on, payment. Yes, done. All right, my lovelies. That is where I'm going to love and leave you. So we are on day 3, and the timestamp will be (6:45). 6:45. 00. Pick up on Monday on day 3. Yeah. It's my bedtime. Sorry. I tried. You love us totally. I do love you, but it's 5 a.m. and I'm supposed to drive an hour and a half away to visit a girlfriend tomorrow. And I don't normally leave the house. So I need a good rest. So I can actually get there at a decent time. I'm sorry. Hang on 1 second. 1 second. I might be able to help this day. Well, I could put day 4 on and just let it run if you want to watch it, and I'll go to bed. I can stream it without any commentary if you want. That's because that gives me runs for 8 hours. You just have to put up with the breaks. That's all. So let me know if you want me to run it. No, we need you. Oh, you pack of dags. Well, it actually goes for a long trial. I didn't think it was that long. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, Christ, 11, 12 days before we even get to closings and verdict. So I reckon I'll be probably doing a Sunday night stream or Sunday morning, your time. Just quietly, because otherwise we're not going to get through them. Oops. So, yeah, there's that. So I'll only be absent for 1 night. Just 1. All right. I don't even know Gotta get up off the chair. Come on, Jodie, you can do it. All right, my lovelies. Mwah. Thank you for joining me again. I'm sorry, I had my grumpy pants on today, and yeah, I'm tired, and I'm sorry. I haven't been much entertainment at all. But I will pull up my big girl panties and be back with you again in one more sleep. Okay. Did she giggle? All right, my darlings. Have a good Saturday, Friday night, Saturday, and I shall see you Sunday. Mwah.
Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.